Greetings of the day, everyone. We are waiting for the participants to join, and for the guest, we will be starting the workshop very soon. Please have some patience. Thank you.
Camera off करा नहीं है म्यूट कर कैमरा ऑफ कर दिया म्यूट कर ठीक है इसको ले जाओ डायरी लाओ पेन लाओ ये क्या है इसको निकालो ये लो ठीक है दरवाजा बंद करो
Good morning, respected Dean and Director, distinguished speakers, esteemed faculty members, and dear participants. It's my immense honor and privilege to welcome you all to the workshop of 7th edition of S.K. Misra Memorial International Mediation and Negotiation Competition 2026, organized by Lloyd Law College and its premier ADR society, the Lloyd Institute of Mediation and Negotiation. This is a prestigious competition that stands as a global platform dedicated to nurturing excellence in mediation and negotiation. It reflects the growing importance of alternate dispute resolution in modern legal systems, where dialogue replaces conflict, understanding replaces confrontation, and resolution replaces litigation. This workshop is not merely an academic event, but a step towards shaping future mediators, negotiators, and dispute resolution professionals. To formally commence today's workshop, I take great pleasure in inviting Ms. Ira Majid. Now, I hand over the mic to my co anchor, Ms. Arpita, to introduce our honorable guest.
Ms. Ira Majid, Honorary Director of Lloyd Law College and Chairperson of Lloyd Institute of Mediation and Arbitration, is a central government standing council and the Director of Indian Institute of Arbitration and Mediation and Asia Pacific Center for Arbitration and Mediation. With over 18 years of experience in criminal, matrimonial, civil, commercial, banking, and finance matters, she is an APCAM certified mediator, APCAM International certified arbitrator, and IMI certified mediator. Ma'am is the executive director of APCAM, and she serves as a mediator with the United Nations Development Programme, World Intellectual Property Organization, the Delhi High Court Mediation Center, and various other international arbitration and mediation panels. She is also the co-founder and secretary general of the International Federation of Mediators in France and a faculty member of IIAM. A recognized leader in her field, Ma'am has won the BIAMC Top 10 Mediators Award in Asia Pacific and authored several books on mediation. She has judged in prestigious competitions such as the ICC Mediation Moot in Paris and WIS East Moot in Hong Kong and Vienna. Ma'am, we kindly request you to address the teams and the guests.
Thank you so much. Good morning, sir.
Morning.
Yeah. So thank you so much, Arpita, for the kind welcome and introduction. So good morning, everyone. It is my absolute pleasure to warmly welcome all of you to workshop SK Misra International Mediation Competition. This year is very special for us because it marks 7th edition of this competition. What started as a small idea has now grown into something truly meaningful, and seeing all of you here today make us proud of how far this journey has come. We are delighted to have about 80 teams from the various countries joining us this year. Your presence has made this platform truly international. Just like the previous edition, I am confident that this year too will continue the strong legacy of success that this competition has built over time. At the heart of this workshop is mediation. And the mediation is not just a method of resolving dispute, it is about listening, understanding, and finding solutions together. As a mediator, myself, I truly believe it is the future because the world needs more dialogue and less conflict. We are deeply honored today to have Senior Advocate Mr. Sriram Panju as a keynote speaker. Sir is not only a distinguished senior advocate, mediator, and arbitrator, but also a pioneer of mediation in India. For many of us, including myself, he has been a great inspiration and mentor. Sir, your guidance and vision continue to motivate generations of mediators, and we are truly privileged to have you us today. We are equally delighted to have Mr. Pascal Commervilles, who will be joining in some time with us, who will share his insight on the role of client and counsel. Pascal is a respected mediator, negotiator, trainer, and also a very close friend whose practical wisdom always leaves participants with the valuable lessons. We are also honored to welcome Ms. Kathleen Ruanleed, who will be speaking on the role of mediator. And Kathleen is a wonderful friend and an exceptional mediator and trainer brings a great warmth and a valuable global perspective to mediation practice. And I'm very thankful for her for supporting this event for last many years. We will also have a session on the drafting of plans led by Pushpit Singh, a promising associate of TMT law firm, one of the most promising young mediators. It truly makes me proud to see how young generations are growing and contributing to the meaningful ways. Then we have a mock mediation session, which will be conducted by my wonderful team from the Lloyd Institute of Mediation and Arbitration, and who will be giving a practical and experiential understanding of the process. Finally, I would like to especially welcome to all the participating team. The skills you develop here, communication, patience, empathy, negotiation, teamwork, and leadership will stay with you for your life. You are not just preparing for a competition, you are preparing to become a professional who can bring people together and create an understanding in a divided world. And that truly, this is the difference this experience will make in your life. More than anything, mediation is a life skill. It teaches us how to listen without reacting. And also, it is more than anything, like it is a life skill, and you will understand that how to resolve differences with dignity. I encourage each one of you to participate actively, learn from one another, and make this opportunity most useful and most memorable. I also would like to thank sincerely our president, Mr. Manohar Tharani sir, senior dean director sir, Dr. Salim sir, and the organizer, and everyone who worked behind the scene to make this seventh edition possible. It would not be possible without all your continued support. Once again, a warm welcome to all of you. I wish you a wonderful, enriching, and memorable experience in this competition. Thank you so much. Over to you, Simran.
Thank you, ma'am. Your inspiring and encouraging words. Your vision truly motivates us to pursue excellence in ADR. Thank you so much, ma'am.
Thank you.
Ladies and gentlemen, the S.K. Misra Memorial International Mediation and Negotiation Competition has established itself as one of the most prestigious ADR competitions globally. With participation from hundreds of students and institutions, it has become a benchmark in mediation, training, and education. I now hand over the mic to my co-anchor, Master Daksh, to introduce and welcome Ms. Daisy.
Thank you, Simran. Ms. Daisy Pallavi is a legal professional specializing in alternate dispute resolution and matrimonial, with experience in litigation, arbitration, and contract drafting. Foundation for Legal Aid, representing survivors across various legal forums and contributing to legal advocacy and dispute resolution. She has actively participated in national and international negotiation and mediation competitions as a judge, assessor, and young panelist, including the third Virtual International Negotiation Competition VINC and the WICCI Arbitration and Conciliation Council Conference. She also serves as the event director for the S.K. Misra Memorial International Mediation and Negotiation Competition for the past 6 editions. Her professional experience includes work with the Law Chamber of Aditya Misra, 𝐒𝐔𝐁𝐄, and the Indian Institute of Arbitration and Mediation, with hands-on expertise in drafting arbitral awards and procedural orders. A published researcher, her areas of interest includes FDI, tenancy rights, online data protection, and ADR-based domestic violence resolution. Ma'am, we welcome you to Lloyd. Over to you, Simran.
Thank you, Daksh. Thank you so much for that short intro. But I think welcoming to my home is nothing sort of a very heartwarming moment for me. Good morning to all my respected seniors. Good morning, Salim sir. Good morning, Madam Ma'am. Good morning, Shriram sir. Good morning, everyone. Thank you once again for coming to my own SK Mishra Memorial International Mediation and Negotiation Competition. Whenever this name comes in and whenever we start this journey, I think it starts basically from November of every year. And we start this journey opening the registration brochure, drafting of brochure, opening registration, and having an ample number of teams is something that is very close to our heart and is a legacy that has been continued forward since 2019. 2019, we started this journey, and with no thought of this mind that this would be such an achievement for this Lloyd Law College and this competition in itself. Trust Legal, Sudhir Mishra sir, Ira Majid ma'am has been the backbone of this competition to support, to let this competition grow to what it is today. Hosting more than 100 teams online, virtually, was a challenge to us in the very second edition of this competition. But with the strength of this team that stands today, all together we fought through it. And today it is what we bring to you. Welcome you all the participants. Live through it, take this journey forward, and I think the workshop today is going to give its best. Thank you, everyone.
Thank you for the introduction and encouraging words, ma'am. It is now my great honor to introduce our keynote speaker, Senior Advocate Sri Ram Panchu. For the same, I invite my co-anchor, Sanskriti.
With 49 years at the bar since 1976, Mr. Panchu is a senior advocate practicing in constitutional and commercial law. An alumnus of Government Law College, Mumbai, he began practice at the Madras High Court and was designated senior advocate in 1996. A pioneer of India's mediation movement, he established India's first court and mediation center in 2005 and has trained more than 1,000 mediators. He has mediated major commercial and public dispute referred by the Supreme Court of India, including serving on the panel of historic Ayodhya Ram Janmabhoomi Babri Masjid dispute in 2019. He is the author of several books, including Settle for More and Mediation Practice and Law. Former member of National Legal Service Authority and former director listed with International Mediation Institute. He also served on the committee that shaped India's Mediation Act, recipient of Bar Association of India's Award 2018, the Anil Diwan Award 2022. He remains a leading force in advancing mediation in India. Sir, we welcome you to the workshop. I request you to kindly address the participants.
Thank you very much. And good morning to everybody. It is especially nice to see my good friend, Ira Majid, and to say hello to Dr. Salim and to Daisy and to all of you. You're bang on time, I must say. Huh? You're absolutely bang on time. Remarkable. So, now, is there any way that I can see all of you on this screen, or is that not possible?
Dear sir, this workshop is online. So,
okay, all right, okay. Because I seem to be looking at myself, and that is.
So you want the spotlight to be removed, sir? So we can remove the spotlight.
Does that matter?
No, that is fine. So
it's
now,
okay.
now it is fine, sir.
Now it's fine. It's far more interesting. Look at all of you than look at myself.
Okay, sir.
All right. You know, we mediate for the right reasons. It's one of the established ways of dispute resolution. It used to be called an alternative method. Then it became an appropriate method in ADR. And somewhere now I think we need to switch to saying that it's actually the better method. It's the better method, not for all forms of conflict. There are certain forms of conflict which have to go only to a court. If it's about an interpretation of a statute, if it's an issue of rights, if it's an issue of social justice, if it is a broad panoply of criminal cases, public matters, there are lots of cases which must go only to a court. And there are some cases fitted for arbitration, where you need a lot of technical evidence. But for the broad mass of personal, commercial, civil, and property conflict, mediation is much the better way. And I like to highlight it by talking about 5 or 6 boxes. And these boxes are time, the time it takes to resolve conflict, cost of resolving conflict, not just in terms of what you pay the court fees and lawyers, but your mental and emotional costs, your cost to your health, control over the outcome. In any other form of dispute resolution, parties lose control over the outcome. In a mediation, they retain control over the outcome completely. Then there is result, the quality of the result. You might get a result in a court which is legally correct, but it may not. It rarely provides a practical answer. And it may not even address, your main question. If you get a result based on limitation, for example, jurisdiction, it doesn't answer your main question. And then there is participation. Who participates in a mediation? When mediation starts, people come into the room and the lawyers will take the chairs next to me. And I will say, sorry, that's not for you, that's for the parties. You move back one step, you're important, but you're not central. And enforcement, the ease of enforcement. In any other system, you may get a decree, but you will have to go through several hoops before you can enforce it. A mediation settlement is the easiest to enforce. Because no court will entertain objections against a mediation agreement. And B, more important, people never go to court to challenge a mediation agreement. It's something they both agreed to after deliberation. So why would they ever challenge it? And I'm going to give you an interesting statistic. I've mediated since the early 90s. So that's what? I hate to say this because it shows how old I am. How old is that now? 20, 10, 20, 30, 34, 35 years? Guess how many cases I've had which have gone to court with a party challenging the mediation agreement? Any one of you like to take a guess? Come on.
1/4 of one, sir.
Not one.
Oh, great.
Not one case has a party gone to court and said, we are challenging the mediation agreement. And that tells you something, because enforceability is important. One of the main considerations when people think about dispute resolution. Now, these are the things which we need to highlight. You know, when we talk to others about mediation, whether it is somebody at home or somebody in our group or somebody you meet on a train or an aircraft or somebody you talk to in a convention, a meeting, or if you're addressing a meeting somewhere, these are what you need to highlight. Because these are the real ground level, brass tacks, practical reasons why people should prefer mediation and look at it and choose it as a first step. And not just a first step, it's something that can be used even if and after people have tried and gone through other methods of dispute resolution. You can use it through arbitration. You can use it through the court proceeding. You can use it after arbitration, after the court proceeding. It's so flexible. But we need to highlight that, look, you should go to mediation, not just because we say it's a nice way to mediate or it's a good way to mediate. Practically and effectively, these are the reasons why you should mediate. You take any of these boxes, and this is what I do when I talk at conventions. I say, take a piece of paper. These are the 6 boxes. Now look at litigation or arbitration and mark a tick or a negative, a positive and a negative for each of these boxes. And then take that same sheet of paper, look at mediation. Now mark a tick or negative. And usually it's a negative mark for any other method. And it's a positive tick mark for mediation. And I say, you know, I rest my case. Why should I try and convince you how good mediation is? You've done it for yourself. So this is what we now need to do. We need to go out and say, for these kinds of cases, and let's make that clear. For these kinds of cases, there is no superior method to mediation. And the sooner you realize it, the better for you. Don't mediate because I'm telling you to mediate. Mediate because you have come to realize that it's in your self-interest, your enlightened self-interest. Because it's time we hit the high road now. You know, when we started out 30 years back, we were like a side alley. When I used to talk about mediation, people thought I was talking about meditation. It took me some time to overcome that. People coming to my talks with yoga mats under their arm. And why 𝐅𝐨𝐥𝐿𝐴 Panchu, who had a good professional legal career, was abandoning it to go into, you know, teaching yoga and deep breathing and all that. But anyway, we moved from the high road and we moved to the district road. And from the district road, we moved to the state highway. Now I think we hit the national highway. We are the golden quadrilateral. There is no other way this country's justice system will survive without the wholesale adoption of mediation. And there is no other way hundreds and thousands and lakhs and millions of people will find an effective answer to their dispute. without mediation. And there is no other way we can convert a civilization which has now, I think, entered the deep throes of conflict. Conflict is so pervasive. If you look around us, we are a civilization which can be characterized by conflict. And there is no other way we can deal with the ravages of that other than to introduce, popularize, and use mediation. There's a small story I will tell you at the end. If I forget, just remind me. But I think you should also mediate for, not just because it's good for everybody and good for the system. I think you should also mediate because it's good for you. You know, it's good for your heart, it's good for your soul, it's good for your mind. And if the Almighty is maintaining a credit list somewhere, you'll get a lot of points on it. There is something I like to call the joy of mediation. And you should experience that. I'm not taking away the hard work that we have to do in mediation. The hard work of preparing, the exhaustive hours at the mediation table, having to go through a day where emotion is just thrown at you at different angles, and feeling completely drained out at the end of the day. There is a lot of hard work. Constantly thinking about the case and how to move forward. But there is a joy in doing what you do. Because what you're doing is to help people make their lives better. You're healing with skill. How many of you know Saint Francis of Assisi's poem? It starts with words, Lord, help me to be an instrument of thy peace. Please Google that. It's, I think, the Mediator's poem. Because you are leading people from darkness to light, from their anger and their conflict into resolution. People who've been separated for years, come to shake hands and come to think better of the other. You're helping the next generation avoid what this generation went through. Any mediator can tell you so many stories. If you gave me a session on the stories I tell about my mediations, I will take a hell of a lot of time to tell you nice stories in mediation. And by the way, Hiram, I think it's time we compile some of those stories. We all have lots of good stories. But to return to the joy of mediation, the fact that you're using your innate skills, your skills of understanding, your skills of analysis, your skills of empathy, your connection with human nature. And the fact that we mediators are like human beings, we like people. We're able to see the better side of people. And we're able to work through that better side to make their lives better. We have remarkable hard skills of analysis, but we have incredible soft skills of heart. And that's why people come to trust mediators. And there is nothing like the trust you get as a mediator. In any other process, people have to, you're forced to trust the judge. There's a certain kind of compulsion to it. But in a mediation, the trust you get as a mediator is because you've earned that trust. The kind of person you are and the way you conduct it at the table. So there is this joy of you using your skills, of putting them to work for the benefit of people and actually seeing concrete results. It's one thing to write a book and hope that people read it and benefit from it. But to actually see results at the table, something important being resolved, relationships getting better. And all these are important relationships. Whether it is within a family, shareholders in a company, people who live in a community, all these are important issues and important relationships. And you're helping to make them better. So you must take joy in your work. And I think if you take joy in your work, then you're lucky. How many people are there in the world out there who can say, my work is my pleasure? My work is my joy. You're lucky because we have a chance to be that. So my message is go out there realizing that you're part of a privileged group, that you're practicing an art which is the best way of conflict resolution for a whole range of conflict, and that you will have joy in your work. But you must look for that joy, and you must learn to recognize it, and you must learn to savor it, and take joy in joy. And keep some of these mediations with you. The ones you do which give you that special joy, keep them with you. Maintain a little journal and write about what you did and how it helped parties. And those are little nuggets which will in time come to be some of the most precious possessions that you have. I did a mediation, one of my earlier mediations. It was actually one of the first when we started the court center in 2005. And it was a new thing to everybody. To judges, to lawyers, to parties, to media, everybody, it was new. And we didn't know whether it was going to succeed. I mean, what? We were like, this country has been through hundreds of years of using the adversarial system. And here we were a bunch of half a dozen people who thought we could do it completely the other way. To have consensus in sort of adversarial. I mean, just look at that, how crazy it must have sounded at that time. But anyway, when the gods smile on you, they smile on you and they give you a chance. So we started the center, and about 4 or 5 cases did work out, and I was getting a little panicky. And the 6th case was there. It was a contractor had filed a case against the owner because his bills were not paid. And it settled in 2-3 sessions. You know, they came to an agreement, it was signed, the check was given, thing was over. And the minute this was done, the contractor's wife, who was with him in the session, she just touched my arm and said, "I'd like to speak to you for a minute, sir." So I took her aside, and she said, "You know, sir, my husband has cancer, and we desperately needed this money for his treatment. And we couldn't afford to say it during the mediation because that would give the other side an advantage. But now that the agreement is signed and the check is given, I want to tell you this, and we will be using this for his treatment." So I said, "Well, you know, I'm sorry to hear that he has cancer, but I'm glad this has come through, and now he can be treated." When that lady left that hall, the mediation room, she turned around the threshold and she told me something which will always stay with me. She looked me straight in the eye and she said, "Sir, this is not any ordinary room. It is a house of God. It is a house of God." I can tell you that at that exact moment, I just became convinced that mediation was going to work. I had no doubt ever after that moment. Before that moment, yeah, something says recording has stopped. Should I stop, or? I think the recording machine has had enough of me. Should I go on, or what do I do? Go on. That was 2005. In 2011, I was going down one of Madras's roads in my car, and there was a knock on the door, the side. We had stopped in a traffic light. A couple in a scooter. I didn't recognize them, but I told my driver, "Just pull up. Let's see who this is." And it was that couple. And the lady said, "You don't recognize us." But we were the couple who came in that mediation in 2005. And she said, "I'm happy to tell you, sir, that my husband's been treated. He's recovered from his cancer. His work is going well. The children are doing well at school. We're a happy family." So I said, "God bless you." But it wasn't just God blessing them. I think God was blessing me as well. So you will get, any mediator will get these kind of stories. But this is how you actually touch people's lives. and how you use your skills and your own inherent nature that's what I want to wish you, as much as I will wish you good success in learning about mediation and learning about practical skills and techniques, all of which are important. I want to tell you that please be aware that there is a joy in this process. And it will come to you. I think I just have a couple of minutes, so I will. It's a field which is changing. We started with court-annexed mediation. It seemed to be the only way to start because it wasn't getting traction any other way. But court-annexed mediation has its problems and has its limitations, both in terms of quality and in terms of approach. And I think we're now have realized that really the way ahead is through professional mediation, where people have a right to choose their mediator, where courts refer cases to mediators in a professional capacity, not just judges, but also mediation centers, court mediation centers should encourage professional mediation. Because that's the only way to grow as a profession. That's the only way it will be sustainable and produce quality and numbers. There are also some other ideas that every company should have a mediation officer, like it has a cost accountant. It is good for companies to have the facility of mediation to sort out internal disputes as well as external disputes. We have to find a way by which we can energize law firms and make it financially attractive for law firms and lawyers to encourage clients to mediation. And that's by way of, enabling the concept of a mediation settlement fee, which is an incentive. We must find ways of taking government disputes to mediation. That's 48% of what we have to disputes in the country. And that's a way of, providing immunity to officers who negotiate settlements. We must bring mediation into panchayats. We often say that's where it started. But we must actually then put mediators in panchayats. That will be grassroots tackling of issues. One of my dreams is that we look at an Indian mediation service, a full-fledged service like the judicial service. And I hope that in time that will come through. Yeah, it's a long list. We've traveled a good way. There's a good way more to go. Yeah. But let's work hard and let's have fun doing it. And keep the joy. Thank you very much.
Thank you, sir, for your invaluable insight. Your words have truly inspired us and deepened our understanding of mediation, both as an art and as a responsibility. We will be waiting for 5 more minutes for our next speaker to join, and the slot will be started soon.
Mr. Pascal is here, Simran.
Thank you, ma'am. Our next session focuses on understanding the crucial role of clients and counsel in mediation. It is my honor to introduce Mr. Pascal. Mr. Pascal is an IMI certified mediator, a MFN registered mediator. He followed mediation trainings in the USA and Holland, completed an internship at Ericsson Mediation, Minneapolis, USA, and received and hostage negotiation training from Mark Luther and Jack Cambria, PSCT, USA. Mr. Pascal also completed the level 1 to 4 training in kinetic interviewing and integration in USA under the guidance of Stan Walkers. He obtained a master's degree in communication, behavior, and credibility analysis at the Manchester Metropolitan University under the supervision of Don Archer. Mr. Pascal practices and teaches mediation and negotiation in the USA, Europe, Middle East, and Asia. Mr. Pascal taught a special 40-hour family mediation course at the Supreme Court of Singapore as well. He is specialized in family, divorce, and criminal law mediation. He is a guest lecturer at the Maharashtra National Law University, Mumbai, India. He is a former vice president of the Academy of Professional Family Mediators, APFM in the USA, and is co-chair of IMI Appraisal Committee and a member of ISC Executive Committee of IMI. Sir, we are honored by your presence. I request you to kindly address the participants.
Thank you, Deb. Good morning, everyone. Thank you, Sir Siram Pachu, for your wonderful just introduction. Really just valued. Thank you, 𝐅𝐸𝐺𝐥𝐿 Majid, for inviting me to help students, and of course, last but foremost, Senior Director and Dean Dr. Modi Salim. Always a pleasure just to be among the students. So we have 30 minutes, and what are we going to do? We're going to talk about client counsel. I would like, and I don't know if it's possible, if you have any questions, to put them in the chat. I'll keep an eye on them, and I will address them just accordingly. So regarding the client counsel in a mediation, and how does it even work? Well, first of all, there are two parties. They're both one side has a client counsel, the other side has a client counsel, and what you do together, and that's one of the key words, you work together, is having a conversation. Having the conversation about topics which the problems that you're facing as a company, as an organization, whatever it is. The number one thing is preparation. Preparation is key. So study your case well, study your confidentials well, and discuss who is going to address what. And by doing that, you already have an idea how it just should look like. Also, write the questions that you have, the questions to the other party. In a normal setting, you just, the mediator does the introduction, and then you have the opening statement. What does an opening statement means with the client and the counsel? Well, it's just a comfort. You have to see the story as a fairy tale. You might think, like, why is it a fairy tale? Well, fairy tale has a lot of just elements which are just normal. So you start with once upon a time, there was just a problem. However, the situation got bad. And how does a fairy tale end? They live happily ever after, right? And that's where you want to go in the conversation. You want to resolve it with the help of the mediator. So in your opening statement, you might start just in that way. And the most logical way to do it, just have the client do the introduction in that sense. And after that, you have just the counsel just the introduction. So he or she introduces themselves, and telling what the issue is. The opening statement is not a lengthy statement of 10 or 15 minutes, because you want to have the discussion as soon as possible. And how long can you just listen to someone? Not for just that long. You want to just get going. So the ideally mark would be, and that is, of course, it depends on competitions, and there's no right or wrong. But in my opinion, around just the 6 minutes. And what do you do in these 6 minutes? You have a client counsel division, so about 3.5 minutes or minutes first for the client to do the introduction, to lay out the problems. And then the second part is for the counsel. And the counsel just helps also with the structuring of the whole mediation setting. And what do I mean by structuring? First and foremost, when you present it, you signpost, for example. So counsel, when he brings up the topics that you would like to discuss, it's like firstly, secondly, thirdly, right? So you can follow. There's no misunderstanding about it. And what do you see in that typical just setting just the agenda? Mostly you have something about the relationship, then maybe some financial component, and then of course the future collaboration. So keep that in mind when you put forward just the structure. Then the tone of voice. We often hear, well, a lawyer or a counsel cannot show emotions. Well, is a counsel not a human being with own feelings? He or she can still just express the emotions, but guides them more, guides the client what he or she just needs. So after the opening statement, when that's done, you move in just to the next just step up, setting the agenda. And you can take as much time as you want, but on the other hand, you also have to take into account that there's only limited amount of time. An agenda can always be modified, can always just change, because it's a flexible, facilitative conversation. And this is what I see often in competitions. You have prepared everything, and I just see that, and then the opening statement is there. Often I see students reading off of all their notes. You might consider to just only have your bullet points, the things that you want to talk about, and actually just engage. The engagement is just more important than all the blah blah words that you are spitting out. If you have done that, you need to also just keep in mind there's a limited amount of time, as I said, that you have. So count with me. So first is the mediator. Yep, opening statement. Then it's one of the parties with their opening statement, then the other parties with the opening statement, then the agenda. So you already lose 20 to 25 minutes in time, which is really precious. And then towards the end, maybe just the last 10 minutes, you're all of a sudden realize, oh, I did not bring my confidentials. Then true negotiation just starts. So there's only just a small time frame where actually negotiation takes place. So timing, or keeping track of time, is everything. The other reason why I say that is also placing just the caucus. If you as a client or a counsel think, well, this is not just going very well, I would like to confer or have a conversation with the mediator, use the mediator. The mediator is there for a reason. Not only for this summarizing, but also use it as a neutral counterpart to bounce off ideas. If you consider a caucus, it doesn't mean that you as a team need to use the entire time of that caucus. It can also sometimes just be really, really short, just a verification. Also, as a client counsel, if one calls for a caucus, doesn't mean that you automatically call for a caucus as well. The reason of that is you want to listen first what was coming out of the caucus, and then you can always decide whether or not you want to have a caucus. A caucus also towards the end in the last or 5-10 minutes is not good. That's poor planning in my humble opinion, and it's opinion. And the reason for that, because you almost just cut off the entire, just the end of the conversation. You want to avoid that. You want to avoid that the end is going to be messy. When it comes to the end, around the 5-minute mark towards the end, make sure just you wrap up or just ask the mediator just to summarize. And give the other party just homework. Maybe there are certain topics that you won't discuss. The point is for you as a client and counsel, it's not to solve the puzzle. Solving the puzzle would be very great that you checked all the boxes and the problem is solved, but it's not the goal in itself. As a client and counsel, and also from an assessor perspective, we want to see how you do it. Demonstrate your skill set. That's way more important than rushing through things and not listening. Because that's what we also see. We like to talk. We like to be middle point, and we think, oh, that's how we scoring. But there are different ways of scoring as well. If you're looking at role division between client and counsel, it can be just an even division. It's not that the counsel always just talks. It's also not mandatory to talk about the law. Because the law is not the issue, the people are having an issue, right? So if you think that all the law and technical terms, nobody can just follow you. Yes, you can just remind just people of that, but steer away of mentioning just all these clauses and contracts. So keep it just more humanistic. And yes, you as a counsel, you are protecting your client, but it's more protecting to ensure that their needs are met, that the issues are addressed. And you do that by listening and sort of having the silence. Just as I do now. Just having these pauses gives people just to self-reflect. What is going on? What would be just the next step? So that is how you work as a team. The client need, in my opinion, make sure that the conversation just goes and revolves just around you. And if you as a party thinks, okay, the other party is only just having the counsel or having the client keep on talking, So invite them, invite the other one just to speak as well. And you could do that by, hey, I've heard just a lot from you, Mr. Counsel or Miss Counsel. But I'm really curious to know, so what's your view on it, Mr. or Miss Client? Involve everybody in that conversation. And if you have the conversation, have things just written down by the mediator. When they're setting just the agenda, when you have brilliant ideas with option generating. Because at one point, you have to think of solutions. So the problems are clear, and that's setting the stage of the mediator, which Kathleen will talk about it just after me. But if you have that, then you're going to generate options. And options, it can be as crazy as it can be. Don't limit yourself as a client of a counsel. If it will actually work, that's something else just for later. What you otherwise do, you limit your ability. So to have the ultimate solution, and invite the other party as well to do that, to have that conversation. Are there any questions so far from any just people who joined this call? And if not, then yeah, are there or not? Let me see. Yeah, okay, yeah, somebody raised his hand. Congratulations. This is what I love to see, that somebody raises his or her hand. So you're not afraid, because here's the thing with the competition, all eyes are on you. And Iswara, I see, can you tell the mediator's role too? Well, Kathleen will do that afterwards. I'm not going to sit in the hot seat of Kathleen and take everything away. So she will address that. But okay, somebody else raised his or her hand. Can you?
Yes.
What's your question?
Hi. My question is with regards to how exactly the mediating pair, the client and counsel, can use the mediator in the session. Like, how do I put it? So you know how when the discussions are going on in the joint session, and perhaps the other party is maybe going round and round on the same things, repeating the same thing over and over again, and we're not really sure what to do. At the same time, we don't want to be aggressive either, right? So how do we involve the mediator in such a situation?
Okay, great question, because it's always dealing just an impasse. Well, either you can ask the mediator for a caucus or just address it in that way. The other way to do it, you can do it yourself as a party. And a way to do it is by mentioning it. So it seems to me that we're going around in circles. Or we're coming back to the question, what do you need in order to move on?
Oh,
Yeah?
okay, that makes a lot of sense.
Yeah, you just ask. You just ask the question. It seems, or I noticed that you're really struggling with this point. What is bothering you? Or how can I help you? Right? So these questions could just help just to address it. You often see it that you don't want to exclude, and you just tell like, hey, this is the concern that I have. Or you let people, or if you have something, you tell them, you're like, I thought of this and I have something very interesting, which might help you to solve your problem. What do? Automatically people want to engage. They want to listen what you have to say, right? And that might just steal them over the edge. And then you ask them, so how does it sound to you? What do you feel like? So also, if the other party is just throwing down proposal, don't shoot it off just right away like, oh, it's impossible. No, understand. How does it work? What do you mean by this? Ask for clarification. Does it answer your question?
Yes, that does. Thank you so much.
Yeah, okay, cool. The other one, Jahavi, good morning. I have a question in this competition. Who's expected to speak more, the client or the counsel? I would argue, and it's that it's just that's in an equal way. Sometimes the counsel is more vocal, and then other times it's client more vocal. What I preferably would like to see is that the client speaks a little bit more, but is supported by the counsel. So if you would have a rating or percentage, then I would say 60% client, 40% the counsel, because it's also sometimes in a competition, it's always stressful. All eyes are on you. There are judges sitting there, and yeah, how do you handle that? And sometimes you are lost for words. So either you could pause, like I do now, to clear out my brain, or you can just give the floor to the other, to your colleague, to your fellow student, which either just is client or counsel. So it's a flow, a constant flow in that sense. Hope that answers your question, Yahi. If not, just let me know. Then I go to Aditi. Well, thank you. I didn't understand exactly how the process takes place and what exactly will the client and counsel say against the mediator. Can you may lead the example? Yes, of course. The process itself is first mediator's introduction, then the client and counsel introduction from one hand, then the other client and counsel will just will have the conversation. Then there will be setting the agenda with all the points. Then you discuss the topics. When it comes to the topics, you generate just options. And if the things are on the table and you've finished them, then you close it. And saying just against the mediator, if you are lost, you ask the mediator, okay, mediator, I don't know where we are with the agenda. Can you help me summarize? You just ask for help from the mediator. The mediator is there to support you in the conversation. As mediator, it's really hard just for me just to talk about this issue. I have another issue that may be just in your confidentials. I would like to talk to you about in person or like in private. Can we have a caucus? Such questions you can ask just to the mediator. I hope that helped Aditi. Isha, I see your raise your hand. I'm gonna just go first. Let's see to Guta, and please give me an outline of the roadmap for the client and counsel and mediator. Well, I just gave Guta, I hope that answered just as well. If not, just put it in the text. Isha, go ahead. What question do you have?
Firstly, thank you so much, sir, for your guidance so far. So my question is basically, what should be the ideal division of roles between the negotiating pair?
Sorry, can you repeat your question again? I want to just understand it really well.
Sir. So what should be the ideal division of roles between the negotiating pair, like the counsel and the client?
Okay, Isha, it sounds like boring, but it depends. Some people are just more talkative than other people. Some people feel more comfortable with saying one thing or the other thing. It's a natural flow. The most important thing is with the role division, discuss it up front, and because you don't want to have a whole scene where one talks and the other one talks. So that's why I'm just emphasizing on prepping is everything. Okay, are you going to say this? Okay, I will say that. If they're going to ask this, then I might answer that. So that interactive play, you have to know the other person that well. And most likely, because you're working in teams, you already practiced in that sense. So know your partners very well and prep. And last but not least, also afterwards self-reflect. What went well, what went wrong, and what can we do differently? And the last but not least, this is a competition. There's so many opinions out there. Also from judges. Judges might be saying like, well, I want to have more this. I want to have more style of that. This is wrong. This is right. Everybody has their own interpretation. But you have to ask yourself, did I do everything with the knowledge that I have right now to make this a success for myself? And did I learn? Because the learning experience tops everything. It preps you for the real world. And never forget, you're always negotiating. You're always negotiating wherever you go. If you go to the market, you buy just something, what do? You negotiate about the price. So you know how to negotiate. Now it's just putting more in a more practical setting, and that makes the difference. And last but not least, I see just this question of Gutek, please give the roadmap of what each person needs to follow in order to make it look good organized. Well, it's all about, again, about preparation. Who is just going to do what? What I see with a lot of students from India, they write everything down. Writing everything down really just helps, rehearsing it, and be prepared of that that everything that you have prepared at first could just go just a way other way than you've just expected. So be flexible in that sense as well. How does okay, Ismail, you said how does Batna and Batna play a role in the competition to be successful, sir, when the negotiating parties come rigid alternatives? They want to have how we can make ZOPA possible. Well, it always just plays a role. When it comes to your opening bid, when it comes to financial part, people are hesitant to throw out the numbers. But if you are the first one, you're anchoring, you're already putting a ballpark on it. So the other thing is people love round numbers, 10 lakh. Right? It's always like a zero. Why it's always ending up to a zero? It's just as an opening bid, just to have the starting, just a conversation, and ask. And if you don't see any room, ask what they need or what help them. Just you understand why this is their final bid or how it's built up. What are these numbers? What do they mean? Or you have the monetary value, but there also is the non-monetary value. Maybe it's goodwill. Maybe it's that you'll just have a joint statement towards towards the press, to the public. Could be anything. So if you have the numbers always just being bitten on the board, so we know what's going on. So that's again where the mediator comes forward. Does it help, Isvara? Isvaria, sorry, that's my.
Yes, sir. Thank you so much, sir.
Okay, good. I think it's my time to wrap up. Is that correct? I need to just have
sir,
a
I
cue
just
from
had
the.
one more question, if
Yeah,
it's
go
fine
ahead.
with you. So considering that this is a negotiation round, should the council cite case laws or statutes as in we do in moot court competitions?
Please, yeah. I personally would just stay away. Again, what's the issue? Is the law the issue or people having an issue? People having just an issue, you're a counselor, so you give advice, right?
Right.
It's not your traditional monologue, just stating just as in moot court, and I would argue this and this law and this section, so and so on. Is that all about? No, you want to. What we see is that people want to be listened to, want to be felt heard, and if you work on the relationship, and the relationship, this is the other thing. Relationship consists of trust, security, respect, and communication. If one of these elements are missing, your relationship goes south. That's why you're sitting at the table. So it's all about this words as trust. And you can ask them, so what does trust mean to you? Anything like that. There's no right or wrong just in that sense, but refrain from mentioning all these law articles and whatsoever.
All right, so thank you so much, sir.
Yeah, you're welcome. And then as the last one, because otherwise Simran is going to yell at me, which is okay, Simran.
No, sir, here everyone is here to learn, and we are. Your words are so much inspiring for us.
Gotcha. Okay. Let me see. Could you please explain the role of the client? The role of the client, well, hey, you represent a business or an organization. So you stand for your values. You want to make sure that the problems that you have are A, being addressed, and A, being listened to, and C, being worked upon, that you can just find just a solution for them. That's a role just as of client, to get to and to listen to the other party as well. It's not all about you broadcasting, sending. It's also about the other party and listening what they need, what they want from you. There's always just something, and if they not, if you have the feeling, there are a few questions that the client can always ask or a counsel is, what do you need? What's the problem? What's your concern? And if they go blah, 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 and there's all these problems, you ask them, what's your proposal? And if they come up with a proposal, you ask them in the end, how would it work? So have them around these, your conversation setting around these core questions. Okay, then when the law is not being discussed by the council, then what does the council does there? Does he too, with the client, just talks about the issues? It's mainly focused just on the issues. What I see is that it brings just the council just to the reality check. How does it work? It's mostly just with the numbers. Are we going to make sure that this will come to a good end? He does the reality check most of the times. What I see and what will be working. Yes, you can always fret like if this not going to work, then we're going to arbitration or we're going to court. However, I advise my client that mediation is another way. That could be one of your sentences which you can just throw in. Is there any role of client in the mediation is there any role in the client of mediation? Could you let us know the things to keep in mind as a client? Well, client, I would say, listen, feel listened, and if you don't feel listened to, just address it. Stay cool at all times during that mediation. In the end, it's about you, not about the mediator. Yet the mediator wants to show his or her skills during the competition, but it is about you just addressing the problems and working together in order to get them solved. So council makes council makes sure the negotiation will be favorable to the client. Yes, well, favorable first, of course, for your client, because you're sort of protecting the client, but also I see the council also as a double role, because you want to work together with the collaborate with the other. It's a collaborative process. Collaborate with the other council. So in that way, you support that. Could you please support us just with let us know the plan information? Well, the plan, read, and if I understand it correctly, Ayush, but could you please, with the plan information, mediation plan is, okay, what are my goals? How are my buttoners? Which questions I'm going to ask? What questions would I have if I look at this case? If I would put myself in their shoes, Which questions would they have towards me? So you're thinking from the other way around. So stand also, just look at that from their position. Write those things just down already. Just have your solutions ready. That's what a good mediation plan comprises, in my opinion. And otherwise, just look on the internet, or in that way you can use just ChatGPT. What does a good plan involves in a mediation competition, negotiation competition? Have that. There are a lot of sources which you can find on the internet, and even recorded sessions. So, any other questions? When the parties are rigid on their stance, how can the mediator make a ZOPA? Okay, well, with that, if they're just really on their stance, you want to understand why. So you ask them. So what makes it so important to you to hold on to that number? Ask. And the mediator can just ask that, like, so what makes it so important to you? And you ask the same question to the other. And as I said, what do you need? Or how can I help to move you on just to whatever, to get out of this situation? So, Nivashini, go ahead.
Hi, sir. Am I audible?
Yes, you're audible. Go ahead.
Okay, sir. So this question is related to the role of a mediator. So as a mediator, we cannot suggest any solution, right? Because we have to be neutral. So is that okay if we suggest some ideas?
Okay. This is an interesting one, because there are a lot of debates around with the mediators if you can just do suggestions. Yeah. It depends on the competition. If it's all facilitative, I would, in a natural way, you could say like, oh, you might consider, or just throw something vaguely in it, and then let the clients and counsels pick up from there. That could be, but just refrain away. In a normal just mediations, sometimes I would just say that, like, hey, well, this is something you could just consider or just think of, but hey, it's all, of course, upon you. But to get that thing just going, the creative solutions and then planning, yeah, you could consider that. But again, you might hear backfire. You like, well, you're suggesting something a mediator should never suggest. Well, if you're truly facilitative, 100%, you will only just be sitting there and not doing anything. That's not a normal just conversation. You have to stay away of opinions or assumptions. You have to steer away from that. So, did I answer your question?
Yes, sir. Thank you.
Okay, great. MCs. Then should the mediation plan itself be neutral or compromise oriented? It depends on the style, what you do. Try to be so much objective as possible. So if I was the one side, if I had the other side, what would I do? So that's your part of your strategy. And remain rigid is not going to help. You can be adamant, but then you have to explain. You can like, okay, that's non-negotiable, but then I would also ask, okay, why it's non-negotiable? Or let them know, okay, this is non-negotiable. However, I'm willing to give this. It's a trade-off, right? If you just see the best the best mango, and you say like, no, it's definitely 200 rupees. Well, that's ridiculous, 200 rupees for a mango. You want to understand just why. Why? What's the reasoning behind? So that I would say, Misha. So I think I've talked already just enough, I believe. If there are no any questions, and given the half hour that I've been given, I would like to wrap up. The only thing I would like to say, enjoy. It's a learning experience. Everybody's there to learn. If there's one judge who's going to just put you down anything, that's not good. It's all just about you learning experience and having fun. If you don't have fun doing this, there's something wrong. Last but not least, if you just still have some questions you would like to address outside of it, just contact me on LinkedIn. I'm willing just to follow that conversation back and forth. Thank you and have a great day.
For the enlightening session. Your perspective on client representation and ethical advocacy were truly enriching. It is now time to understand the most crucial figure in mediation, the mediator. I am now honored to welcome Ms. Kathleen, and I hand over the mic to my co-anchor, Ms. Saleha, to introduce our esteemed guests.
Thank you, Simran. Ms. Kathleen Ruan Lady is a distinguished bicoastal mediator since 2008, bringing with her over 17 years of experience in dispute resolution. She has successfully resolved more than 1,000 cases, achieving a settlement rate of over 95%. She is particularly recognized for her expertise in handling high conflict matters, including complex cases involving restraining orders. Previously, Ms. Leedy has served as a coach and training coordinator at Family Services of Central Massachusetts, where she played a pivotal role in training mediators and overseeing operations over 5 courts. She has taught mediation programs both nationally and internationally. In addition, at Harvard University, coached students at the judge at global mediation tournaments. Ms. Leedy is also published author, having contributed to the book Worry-Free Divorce, Leading Divorce Professionals Speak. She's frequent speaker at professional forums and events, and holds specialized training in felicitation and restorative justice. Furthermore, she has successfully advocated for enhanced medical discharge ratings for the members of the US Army. Ma'am, we welcome you aboard and request you to enlighten the participants.
Thank you very much for that wonderful introduction. And it was also lovely to hear the tail end of Pascal and all of his sage advice and experience for this tournament. It's a pleasure to be here. I do have a slide deck that I put into the chat, so you're all welcome to click on it and review it and make it yours and keep it for yourselves. And I'm going to ask permission to be a co-host so I could share my slide deck for a half hour together as we discuss the mediator role in this tournament, which there have been a few questions about already. So let me see if I have the ability to share my slide deck right now, which I do. So let's go ahead and hop on this. And here we go. Let me put this in present mode. And this is one of the skills you can use as a mediator. If you're taking notes or writing down when you're mediating, you can talk aloud, because as mediators, we pick up tools. So the role of a mediator is easier than that of a client and their advocate, because we are sitting back and the facilitative style of mediation, and we're just helping them with their chaos. And here's my greeting. We are just helping people with their chaos at the table. And the more tournaments you participate in, you have the opportunity to hone your skills, pick up your tools It's not that we are such great people, it's that as mediators, we have learned to pick up powerful tools that we've learned how to utilize. And your will is stronger than your skill. So if this is your first time, that's okay, because it will be your tool usage that begets your confidence, that rolls into your competency, that rolls into your personhood as your mediator style, your talent, which then begets your mastery. So take your time, take it easy, have fun in this tournament, as Pascal said so wisely, and just enjoy your role when you play the mediator, because it is about picking up mediator tools and utilizing them in real time during the tournament. So let's look at what's going on here. In essence, your role as a mediator is you are the lighthouse. You are strong and solid in your position as the mediator running a process, and you are shining via your mediator style, your mediator confidence, your mediator courage to ask the powerful questions, to summarize the narrative that you hear, to ask people if your summary is correct, to ask the mastery question, is there anything else? These are all our mediator tools, and you can pick up these tools when you're ready to, or you can decide as a mediator you're going to try some tools that you know during the tournament that you are going to be utilizing, because as the mediator position, as the person that's the head of the process, you are simply shining the light into the conflict of their lives, into the conflict of the client's life, into their advocate's life as they are being hired to protect the rights and interests of their client. And you're helping them navigate these positions, helping them determine their position and what suits them best, what looks like a win-win for them. Because people come to your table and into the tournament, they have strategies and they have a bit of confusion, and they may not know what strategy is going to work in the tournament, just like people at the mediation table. They come in all foggy about their chaos. They come in all in the dark about their chaos. And it's your revolving beacon of shining the light into their narrative, into the paperwork that the tournament has given you as the role play. You're a powerful lens. You're creating sweeping change, and your skills are rhythmic. Like my narration tool of thank you very much, gratitude tool, thank you very much. My next tool, let me make sure I heard what you said. This is what I heard you say. My neutrality, I'm going to say to one lawyer client advocate, this is what I heard you say. And my neutrality means that the other side of the table, I'm going to be saying, this is what I heard you say. Is that correct? Is there anything else? This is a rhythmic routine of shining light into the disputes. You are the person who is stable at the table. You're in charge of the process. Like a lighthouse, you're not moving, you're not changing. You are nice and strong and stable, and you are providing light through especially your power of narration at the table. It's your power of narration that lets people hear what they've said to you. It's one thing to tell your mediator all of this stuff. Another thing for you to say it back to them, for them to hear their own words. Now you're speaking to them. When you ask parties at the table, is that correct? Yes, that's autonomy and agency and psychological safety. Yes, it's validation, but it's also other things. It's structure. As you provide the light into what someone just said to you at the table, when you ask them if that is correct, after you summarize back what you've heard, and they say yes, they've accepted responsibility for those words. That's structure. You are looking for people in this tournament to accept responsibility for what they're saying at the table, at your table. And you're providing of the light as they accept responsibility will make your mediation easier, because you're going to remind them that they accept the responsibility for this, because people come to the table with, in the beginning of the process, with historical meaning. This is the chaos. This is the role play that have been given in the tournament. That's the historical meaning. Your mediation table is going to move, and you're moving with, and new meaning is being created. So you're running the mediation process, which equals structure plus flexibility. Your structure is your process of how you're running people through these stages. Your opening statement, their opening statements, that's structure. Your summary back of the opening statements that you hear, you're pinning structure into flexibility. The organic conversation that you hear at your table is flexibility. It's your job to pin structure, into what they're saying. Not so much to interrupt in the tournament because you only have so much time, but there's going to be a point in time when you're in the opening statement stage, you're going to have to summarize what you heard people say. Summarize immediately, very quickly. You're pinning structure to the flexibility of their spoken word, which you can't predict. Your structure is in the written documentation. The flexibility is in their narrative. So you're going to pin structure into their flexibility. This is how we run through a mediation process, through its stages. Through the stages in the tournament, you're giving the time in the tournament to help them reorder the historical chaos of the role play into new meaning of negotiation. And that's important. And you have to track that new meaning and hold people responsible. So right now, as your mediator, use your mediator title. As your mediator, use the structure. Right now, we're in the opening statements. Thank you for them. And let me make sure that I've heard what both of you, all of you have said. Use your structure. Use the table. Right now at the table, this is a very rich conversation, and it seems to be in repetition. So as your mediator, let me make sure that you both are hearing each other and ask people, use the tool of cross summary. Please, each side, please let me know what you're hearing the other side say. And I'm going to start with you, client advocate. What are you hearing the other side of the table say right now? Grab your structure through the flexibility, through the drama, through the confusion. You're grabbing structure. You're grabbing structure when you have an agenda that's been set and you're only writing down the agenda when it's perfect. Don't use the flexibility of what do you see as the agenda and start writing right away. No, you're setting the agenda that's perfect. And maybe you're asking the client advocate to put the agenda into the chat, but you are definitely pinning structure into setting the agenda when you're asking everyone to write down the agenda, not just you as the mediator. You are not here to do all the work. You are here to run a process which includes structure plus flexibility. And flexibility is also your style, your mediator style, your mediator confidence, your mediator courage. That's your flexibility as you apply the structure of the mediation process to this tournament. So make sure there's a clear agenda, even when parties say in their opening statements, and this is what we see as the agenda. That's not good enough. You're just going to say thank you for those agenda suggestions, but you're going to go have your own agenda stage. This is what I heard everyone say as the agenda. This, and this. Is that correct? Is there anything else you'd like to add to the agenda? You're setting the agenda, not the speaking order. Set the agenda structure. Go for the speaking order of each agenda item. Secondly, that structure. So you're running people through this process. When people are at your table and they try to go straight to negotiation too quickly by making offers, slow them down because you're running the process. You're here as the mediator to explore the backstory. You're here as the mediator to make sure they're exploring the backstory well. And if you don't hear them exploring the backstory well, you need to step in for them as the leader of the process and ask them, might we explore some more about this agenda item a little bit more deeply, please? As your mediator, I don't clearly understand fully the backstory of this agenda item. As the mediator at the table, you're going to hear They should be disrupting each other's plan, strategy. And if you don't hear them reality checking, you as the media are going to have to ask the reality checking questions. Can you tell the table more about that? What would, in your offer that I just heard right now as the mediator, what would be the downside for the client that you just offered you? What is the downside to this offer? If you're not talking about how the offer is going to negatively affect the other side, if you're not asking those questions as the mediator, you're not using your full flexibility within the negotiation process. It's always exploration and disruption before you allow negotiation at your table. And because it's the tournament and people are nervous, they may start to negotiate too early and then they get stuck. Excuse me, because they're negotiating too early. So you may have to go back into exploration and say, please tell us more about the meaning behind this offer. Can you tell us more about the historical meaning behind this offer? Can you tell us more about how you see this offer having meaning for the positive effect for the other side of the table? And you're going to know who they are because you'll know their names by them, because in your mediator's introduction, you ask for introductions around the table. How would you like to be addressed? That's part of your structure, as you introduce yourself and ask parties how they would like to be addressed, and you write it down. That's part of your structure. You taking notes is part of your structure. So you have the easiest job at the table because you're sitting back and you're making sure that parties are fully exploring the agenda that was set. You're making sure parties are going through the proper reality checking of themselves and the other side of the table before we hit negotiation. So this is the process that we run people through. And you may be choosing a private session if it's allowed in the tournament, or they may be calling for a private session where you can get more done, more one-on-one, more up close and personal done. And your usage of structure and that caucus session is to empower them, not you, to transmit information, is to empower them to share something different when they come back to the table, or it's to empower them to have a venting session with you as their mediator. That's your structure for the joint session, which we call caucus. And you are taking notes and recording partial points of agreement, and you're interrupting the conversation with your flexibility and your interruption tool as the meter saying, excuse me, did I just hear a partial agreement here about agenda item number 1, about the first agenda item? Or excuse me, it seems like this first agenda item, we keep going round and round. Can you please each of you summarize what you're hearing the other side saying right now? Because I'm not sure as your mediator that you all are hearing each other. Everything that you do runs through the SMART test. Everything you do is specific, it's measurable, it's achievable for the parties at the table, for them to understand you. It's relevant for people at your table, and it's time-based. So you're thinking about time. You're thinking about the past, the historical meaning that was brought to you through the role play. You're thinking about the present movement that's happening at your table, and you've got an eye onto the future for the parties at your table. These are the tools that you're using as the mediator. This is why you're sitting back nice and relaxed, nice and easy, and you're helping them. Because sometimes, most of the time of the tournament, they're not helping themselves very well. They need you to not take up time away from the competition length of time so they can't negotiate. They need you to intervene and keep things clear and clean. So get in and get out. Make your summaries quick. Say, is that correct? Is there anything else? And then get out and say thank you. You're picking up this movement of tools, the ones that you're willing to utilize, maybe even for the first time, maybe for the 14th millionth time, because you've been in many, many tournaments, but you want to use your tools well, because we allow people to proceed through the stages over time to reorder this conflict that the tournament has given to them into new productive meaning for them. The mediation table needs you to make sure it's moving. And if it's stuck, if the table's stuck, you can simply say, excuse me, everyone, I need to interrupt you all. As your mediator, the movement here has stalled. Name it to tame it at your table. Name everything that you're seeing. Name it to tame it is a real psychology. The movement has stalled. As your mediator, let me summarize what I'm hearing. And also let me summarize what I think where this table is stalling. Don't say where you are stalling. Don't make it personal. Where the table is stalling. That's why you use your title as the mediator. You use the word the table. It's a neutral term. It's mediator speak. It's neutral language. And you use the stage that you're in. Right now, we're in the opening statements and you're getting into a bit of a detail. I'm going to ask you to hold off on those details, but thank you for them. Let me summarize what I've heard you say thus far, so far. You said this, this, and this. Is that correct? Thank you. And I'm going to ask you to wrap up your opening statement, please. See how you're directing the process through structure. You are smartly directing this process, but your mediation table needs to move. And you need to make sure that people are staying within the stage of creating the agenda, of having a discussion on each agenda item, of moving to the private caucus. You're moving through stages and you're allowing people to compete with the role play. So you're commanding the process from beginning to end, running it through those stages, and your mediator style, your mediator confidence and courage while you're using your mediator tools. What does this mean? It means be yourself. Don't be Kathleen. Don't be Pascal. Be yourself and have confidence in yourself and your own personality that you can do this, even if it is for only the very first time. You can still do this. So because of being neutral and having an active role, even at a facilitative table, this is mediator speak. This is how you're going to start to talk. So pick up some of these phrases and start to talk this way. Ask these questions. This is how you reality check and use disruption. Have you given any thought to this? I hear you both talking about this. Have you all given any thought to this? What looks like the best case scenario for each of you at the table? What looks like the worst case scenario for this agenda item at the table? You are the disruptor. You are the explorer, and you are the negotiation helper. When you summarize, you're saying, as I hear it from you, I heard your words say, you are saying this, we here at the table are hearing this right now. Is that correct? Is there anything else? And another mediator tool is the guess tool. When you want your table to move, you're going to have enough confidence and enough courage to guess. And how do you guess? You say, as your mediator, it seems, sounds, looks like, or feels like, it seems like, it sounds like, feels like, looks like. Is that? And you're going to name it at your table. And you're going to ask, is that correct? And if you are wrong, it doesn't matter because you're going to get corrected. Whenever another tool is a mediator, whenever you get corrected at the table, you always immediately say, thank you for that correction. Thank you for that correction. As a mediator at the mediation table, we are in a biosphere. We are not in a dominant society of one up or one down. We are humble. So if we make a mistake, we go one down in the dominance. We say, thank you for that correction, which restores our biosphere of lateral power because everyone at the mediation table has equal power. This is what we tell everyone across the world. Everyone has equal power to make decisions at this mediation table. So put this next to you during the tournament and start to practice some of these phrases. Remind yourself of how you're supposed to speak. And here are your tools. And I'm paying attention to time. Here are your tools. I call it mediator speak. When you reiterate summary back to people at the table, that means you are repeating every single word they say. When you're repeating every single word someone just said in their opening statement, you are protecting their culture. You are giving them autonomy, agency, validation, acknowledgement. You are 100% accurate when you are reiterating with your summary. If you're paraphrasing, you are less than 100% protecting their culture because you are substituting your words for their words. So practice the reiteration summary, which is 100% protecting of culture. They are hearing their own words back. 100% accuracy. That's why you're taking notes. That's why you're remembering things. That's why you're writing down keywords. So you can reiterate it back to them to make sure that what's being spoken at your table gets pinned with structure, but also to make sure that you're correct. Also to make sure they're accepting responsibility for their words at your table, which is pinning more structure within the organic conversation that you cannot control until you summarize back what you heard. Reframing is recreating a whole new story about what you've heard. You can reframe when people get stuck at your table. You can tell a story, reframe. Okay, so everyone's come here. Thank you very much for all your efforts, but it just seems like we're not understanding each other. And I'd like to hear you summarize each other because this story seems like it's going nowhere just for now. So let's see how we can improve what's happening at this table right now. You're going to pick up your interruption tool as the mediator. Excuse me one moment. Excuse me one moment. You need your interruption tool. It's your emergency tool. And to do that, you speak faster than the people at your table. You are always using your gratitude tool. Thank you. Thank you for accepting that offer. Thank you for the agenda. Thank you for the introductions. Thank you for your opening statements. Find a way to pick up a gratitude tool and utilize it. And your voice has 3 tools: my tone, my pitch, my tone right now. And if I go up or down, that's my pitch changing my tone. And I do it on purpose for emphasis. And am I talking too fast for you right now in this training? Don't be talking too fast at the mediation table. Your pace, your voice has 3 tools. Utilize them. Chase clarity and accuracy and agreement. That's your job as the mediator. At the end of the day, you are on a fox hunt. You are one of those hound dogs in a fox hunt in England, chasing clarity, chasing accuracy, chasing agreement for people. How does that feel on a scale of 1 to 10? How is that for you? What do you like best about this on a scale of 1 to 10? How are you? What is the best scenario for you? What exactly is bothering you on a scale of 1 to 10? Is anyone upset here on a scale of 1 to 10? Use these tools and your guest tool. Utilize these tools. So your challenge for the table, besides what Pascal said, to have fun and make friends, enjoy yourself and take risks and accept challenges, is to pick up these tools as a mediator and start to gain your confidence and your competency, hence your mastery with these tools. You are helping participants negotiate from clarity and accuracy at your table, not from strategy. Not from strategy. You're helping people negotiate from clarity and accuracy at the table. And that's where your negotiations are going to become clear. And I can see that I don't have my slide here for the strategy tools. We at the facilitative mediation table, we do not negotiate. We do not apply strategy to force feed a strategy into someone, high, low, mediator's figure, walk away number, bracketing. We don't negotiate at tournaments typically. Help people negotiate from strategy. We help them negotiate from clarity and accuracy. So keeping mindful of my time, which I was supposed to be done in 5 minutes. Any questions, comments for me in the role of the mediator? And I saw some comments about the ZOPA, the Zone of Possible Agreement from Harvard. And remember, you might have people that have a zone of possible agreement with an agenda, but they see it differently. So as the mediator, you have to ask, how do you see this happening? How do you see this offer working for you? How do you see this offer working for the other side? Even though the role play may agree that everyone wants the same thing in the agenda, doesn't mean they see it the same way. So be careful of that, Zopa. Make sure that you are respecting the differences as people negotiate an agreed upon agenda item. Okay, questions, comments for the good of the order. looking into the chat what Pascal was talking about as well. Your BATMA WATMA, what's the best case scenario? You can use that two ways. The pure meaning, how we use it at the facilitative table. What does your best case scenario look like if the table fails? It's to a negotiated agreement, which means that the negotiation is failing. So what does your best case scenario look like if the table fails today? As the mediator, you can ask that question. What does your worst case scenario look like today if this table fails? What's the worst case scenario going to be for you if you walk away without an agreement today? But you can also use it as what's done a lot of times in the legal world with lawyers. What is your best case scenario for you? What is your worst case scenario for you in your situation? So you can use it the two ways for sure. I see a hand up. Go ahead and ask that question out loud. Thank you very much for your hand.
Hi, Kathleen. Actually, I have a question regarding about suppose the parties are having a difference in opinion. So, as a mediator, I may have two options. Firstly, I can conduct a caucus, and secondly, I can ask the parties to have the conversation about this matter in the next meeting. So, my question is when to decide what to do among these two options. And another
Remember,
question is there. Should I go after this, after you answer this, or should I
yeah,
page
let
this
me answer
question?
that question first because that's a powerful question. I just used my
Fine.
interruption tool, by the way.
Thank
See how I did that? I got it talked faster than you did. It is your job to chase clarity and accuracy and agreement. So therefore, because it's your job, you're going to clarify. At the table right now, this is what you agree on. And at the table right now, this is where you strongly disagree. On a scale of 1 to 10, how much you disagree? You ask one side that question, then you go over to the other side of the table. On a scale of 1 to 10, how much do you disagree? And when they tell you, then you're going to ask, what do you want to do about this disagreement? What are you going to offer each other to resolve this disagreement? It's not your issue to resolve. It's your issue to make it clear in how much they disagree with each other and what do they see as their options. And if you need to, then use the words that I only use when I reach impasse, only when my table reaches impasse. Impasse is when the mediation table stops moving. That's all it is. It's no big deal. The table stopped moving. But if it reaches impasse, then you say, okay, since the table has stopped moving within this agenda item, does anyone have a creative, out of the box offer to make to each other? Would you like to take a couple minutes to think about that? It's your job to chase the clarity and accuracy no matter what it is. Second part to that question, please, and great question.
Thanks a lot. The second part of the question is that how to cooperate with your co-mediator.
You need to divide up the responsibilities of the mediator's opening statement with your co-mediator. You need to defer to your co-mediator and say, is there anything else that you'd like to say as well? You need to extend the baton to them, invite them. And if your co-mediator is overpowering you, you need to interrupt as well and say, excuse me, in addition to what my co-mediator said, here these are called transition words. In addition to what my co-mediator has said, I would like to add this as well. Or you're going to get in there and say, I agree with my co-mediator as well. This is how you're going to make sure that you are splitting the time, that you are sharing the airways in the tournament so the judges can judge you. It's called apportionment time. How long are you speaking as a co-mediator compared to the other co-mediator in this mediation? Also, as co-mediators, you should be splitting the time that you're leading a caucus. One co-mediator should be leading caucus 1, and you tell people in the opening statements, I, Kathleen, will be leading the caucus 1 if we have a first caucus, and my co-mediator, Benjamin, will be leading the second caucus if we have a second caucus at this mediation table today. You explain that in the opening statement so they can see you are both running a neutral process. So make sure you get in there if your co-mediator is very chatty. Great questions. O'Neill?
Thanks a lot for answering.
Next question.
Hi, Kathleen. I have a question regarding what was just said as well. Let's say your co-mediator, we negotiate before the competition that, for example, my co-mediator will be going first. They'll be handling all the OS in regards to the principles, and I will be handling the OS in regards to the tools and the process. But what if my co-mediator, since they are going first, take a significant amount of time? That means that when it's my turn, rightfully the time allocated for the mediator's OS has already run out. In that
Yes.
situation, how do I deal with that? Because I don't want to take time away from the discussion or the session as well.
Correct. And us as judges, we will realize what's happened, by the way. We know what just happened. We know that you didn't have your chance. So what you're going to do is summarize, very quickly summarize. So like this, my co-mediator has described to you the principles of mediation, the voluntary, confidential, neutrality, impartiality, and the self-determination. Does anybody have any questions about that? And my co-mediator has also talked about the process here today at the table, where we have opening, we have joint sessions, we have private caucus sessions, we will have further discussions, which we will approach negotiating. Does anyone have any questions about that? So you're going to quickly summarize, ask if there's any questions. That's how you get in to the space when someone's taken all of the space away, pretty much. So it only takes you 60 seconds to do that. So jump in there and do that.
Just to follow up on that, so if I still have to cover the process, so in that scenario, do I condense my original planned OS into like something much briefer so that I'll save time in the interest?
You're going to say, we are short on time, transition statements, and let me describe the process very quickly. That's what you're going to say if your mediator takes too much time with the principles of mediation, and you've got 15 seconds left to talk about the process here today at the table. You're gonna name it at the table. Name it to tame it. Everyone, don't forget this, and just say, without embarrassing your co-mediator, now that we're short on time, you can say that at the table. It's okay. In the interest of time, you can say it at the table, and it's called framing. You're framing the fact that you're going to have to whip through the process because of the interest of time. So you're just going to name it in a very nice way. Great questions. Thank you.
Thank
The
you.
second hand I see it. You're very welcome. I see another hand up. Please ask your question.
Hello, ma'am. Am I audible?
Yes.
Ma'am, my question is that the client and the council, they have a pre-meeting so that they have the chemistry to work together. But when a co-mediator is given, ultimately, though we are the facilitators of the process, there we are competitors too. So keeping the time in mind as well as the cooperation we need to have between us, how do we build that particular relationship, ma'am? Like if we want to divide the time among ourselves, divide the role among ourselves, but somewhere one party is as one of the member has already said, maybe overpowering, or maybe they are doing they are taking much time, or if we say that first caucus will be dealt by one, or second caucus will be dealt by another person, and second caucus won't happen. So that case, if one is in a disadvantage, how do we deal with that, ma'am? Like, what is the average time of a mediator to do opening statements to summarize any particular points, or how do we go about it, ma'am?
Your mediator's opening statement between the two of you should be 5 minutes, no longer. You can each have about, 2.5 minutes. I can do mine in 5 minutes. I can do mine in 3.5 minutes. So you want to think about a 5-minute, no longer than 8 minutes for sure, but a 5-minute opening statement. And there's nothing wrong with saying, we're going to be setting a timer. There's nothing wrong with setting a timer and letting the timer add more structure to your process that you're running. Remember, you're running a process, so equals structure plus flexibility. So if you guys agree to set a timer to help you divide the time and the timer goes up, judges, we don't care. We're going to go, oh, that's a great idea. They've got a timer to let them know that it's time now to switch the baton to the other co-mediator. So figure out a structure that works and get agreement on it with your co-mediator. And even though you haven't had time to build a relationship, your relationships already exist because you both have a relationship with the process of mediation. You understand what the structure is in the process of mediation: agenda setting, opening statements, parties opening statements, your opening statements, discussion about each agenda item. You have a relationship with the process. So you don't need a relationship with your co-mediator except responsibility division. and making sure, as I've said, that you get yourself in there. In addition, use your transition words. In addition, I'd like to add, as your co-mediator, in addition, I'd like to add this. And thank you, I agree with my co-mediator. If they're saying a lot and you agree with them, then just say so. Get yourself in there. So as judges, we know how differential you're being, and we're going to give you points for being agreeable. We understand what's happening as judges. Great questions. Anyone else? I see in the chat, when parties are rigid on their stance, just tell them. There seems to be a rigidity here. As your mediator, I don't see much flexibility. And what happens, you don't pit people against each other at the mediation table. You align them with the process of mediation. You say, you know, everyone, there seems to be a lot of rigidity here. You're each very loyal to your positions, but the mediation table requires flexibility and it requires movement. I'm going to be asking you as your mediator to relinquish your hold on loyalty to your position and start to think of solutions to offer each other that will work. That's how you get rid of rigidity, because the mediation has a culture too. And it's not the culture of rigidity. The culture of rigidity, I want what I want, belongs in court, not at the mediation table. And sometimes I say this is not the place for the rigidity of court where you're trying to get everything that you want. This is the mediation table. This table has a culture of exchanging, of offering and receiving. And you realign people with the culture of the mediation table. So it's not so pointed. That's how you run a neutral process. Okay? Any other questions or comments, or is it time for me to go?
Ma'am, one last one. Like when you were telling in the presentation that we are the mediators are the neutral persons who will facilitate the process, and where the parties themselves negotiate, we just fix the process so that it won't go sideways. But when we are making mediation plan, when we are making a Batna and Batna, some preconceived notion that this alternative might prevail will always be there in the mediator's mind, no, ma'am. So how do we overcome that or tackle that particular situation?
If there's something that comes into your mind, you turn it into a question. You are not sitting there dead in the water as a mediator. You are using your own judgment and your own brain power to shine the light into the four walls of their conflict, of this role play, each role play the tournament has for you, which are going to increase in difficulty, I'm sure. You are the lighthouse. So if you have a doubt in your mind, you simply say, as your mediator, how would it be if this were to happen? What does this look like for you? You turn your judgment and doubt into a question and you put it onto the table. If people need you to help, it's only when they need your help, only when you're reality checking. How is this realistic for the other side when we heard in the opening statement that these are people within the system of a government and the government is constraining them? You have to pay attention to your role play as mediators. You have to know that role play. You've got people within systems, and sometimes they don't have flexibility. All they have is structure because they're within a system of government.
Okay.
And they have
Thank
to
you.
operate within that system, and their flexibility is constrained. And the other side of the table needs to understand that, hey, we're constrained. Our flexibility is constrained because we are in a governmental position under governmental regime somehow, some way. And you make that all clear at your table. Okay?
Yes, ma'am. Thank you, ma'am.
Thank you, ma'am, for the insightful and engaging session. Your guidance helped us understand the mediator's role as a facilitator of justice and communication. The next session focuses on one of the most essential technical skill in mediation, the drafting of mediation plans. This session will be conducted by Mr. Pushpit Singh. I kindly call upon my co-anchor, Ms. Preeti, to introduce our esteemed guest.
Thank you so much, Simran. So, Pushpit Singh is an associate at Bengaluru-based TMT law firm. He has experience in drafting and reviewing a range of commercial agreements, including software as a service agreements, employment agreements, data protection and privacy agreements, and policies. Additionally, he advises clients across diverse sectors with a focus on technology, labor, and employment law matters. In the past, he has also worked on general corporate matters, including mergers and acquisitions, and foreign exchange advisory and commercial transactions. His work involved drafting and reviewing key commercial agreements, conducting legal due diligence, and assisting clients with regulatory compliance requirements. He advised a diverse clientele, including Indian corporates, emerging startups. He has publications in various legal journals and blogs, including the EU Journal of Data Protection and Privacy at Scopus Index and Indian Journal of Law and Technology at NLSIU Bangalore. So I request you to kindly begin the session. Thank you.
Hi, everyone. My name is Pushpit, and thank you so much for that introduction. Before I start the session, just wanted to thank the entire OC and especially Iram ma'am for allowing me this opportunity to come and help the participants in my limited capacity. So what I'll be doing today is explaining you how you go about drafting a negotiation plan from a client's perspective, counsel's perspective, that is a team perspective. That's the first thing. And second thing, I will be explaining how exactly you draft a mediation plan from a mediator's perspective. I think that the previous session was very helpful on how mediators can go ahead and conduct sessions. I think in terms of drafting, this is something which I'll be able to contribute a little bit on. So before I go ahead and explain how you go about this, I'll quickly give you a brief introduction on what the problem is and how you go ahead and draft a negotiation plan and a mediation plan. The problem, it's very simple. There was a buyer and there is a supplier. The supplier manufactures EV batteries, and it's well renowned for that. The buyer is an automotive company, and they want to expand their EV segment, and they want the supplier to manufacture special customized EV batteries for the buyer. Pretty straightforward. The buyer and the seller enter into an engagement for around, I think, 3 to 5 years. Basically, they enter into a long-term supply buying sort of agreement. Everything was going fine until certain issues came up during their engagement. And the parties thought that there is production delays in the batteries, there was financial losses, and there was obviously reputational damages. So considering that, there were certain agendas of issues that came about. First one was delays in delivery. Delivery, I mean here the batteries. Second issue being quality concerns. The battery is not meeting certain specific requirements of the buyer. And then third thing being pricing issues, because the buyer wanted the pricing to be fixed. Supplier said, no, we cannot do fixed pricing because the cost of raw materials is increasing. So we want to increase the price of the batteries. Pretty straightforward. And then another issue which came about was about IP. The batteries are something which is very unique to the supplier. So the supplier owns the intellectual property rights to the battery. But apparently the buyer started reverse engineering the battery and trying to copy the battery, essentially. That's the allegation flying around. Another issue that came about was termination. The buyer said that we cannot continue like this anymore. It's causing us a lot of issues, delivery issues, quality issues, etc. So we want to terminate the agreement that we have. And the buyer says, let's do it right now. But the supplier is saying, no, let's not do it right now. I want to continue the engagement with you. This is the context of the mediation. And considering these issues, the parties entered into mediation. And now before the mediation happens, what do you do? What do you essentially look for? So I will share the screen and show you a draft negotiation plan. And I'll show you how you can go about it. Just give me a second. I'll share my screen. Yeah. Okay. So this is a negotiation plan for the requesting party. The requesting party here is the supplier. Again, the person who is manufacturing batteries. Here, the first thing that you have to show in your document is, or rather in your plan is, how are you essentially dividing the roles between a client and a counsel? Here, if I was to put it into simple words, client is the one who gives the narrative on the issues, that is the background, the story, and commercially what is exactly happening. For example, here, the supplier is saying that we are facing supply chain issues. Supplier is then saying that there is rising costs. Then supplier is saying that we want to identify mutual areas and not terminate because we want business. We want to get money. We want to continue with our business. And obviously showing that why long-term relationship is important. This is something which the client will be saying because the client is the one who owns the company, or rather it represents the interests of the company. So give the background, give the story here in bullet points. Keep it very straightforward and simple. You don't have to give a very long narrative here. This is from the client's side. And this is what the client's role will be. Counsel's role here would be for the supplier. It's pretty generic, but I would say that you essentially as a counsel have to first help your client identify what the issues are. Then second, help the client see what is the potential solutions available. And you have to show your client that if you adopt a specific solution, what will be the consequence of it. And you have to show your client that if you want to go for a specific solution, what are the compromises you would have to make. And obviously by guiding the client onto the best possible courses of action, giving the best to worst case scenarios, and then obviously assessing the legal risks associated with it and explaining to your client. For example, if the contract is terminated, what happens? If you don't have your IP anymore, what happens? So those kind of things, and that's how you essentially divide the role and you put it into the negotiation plan to show that the roles are pretty clear. It should not happen that the client is giving, advice on the legal risks, because that's not something which the client is qualified to do. Sure, the client can give an opinion on it, but that's not really what the client's role is. So to keep it very simple, client, commercial story, counsel, more practical and more legal story. That's how you divide the roles in practical session and in the negotiation plan also. This was the first limb. Second limb, you have to identify the needs and interest of yourself. If you are the supplier, the one who is manufacturing the batteries here, you have to identify your needs and interests. And then you have to identify the needs and interests of the other party, that is the buyer. And that's what you have to write down here. Second limb is your interests and needs. Third limb is the needs and interests of the other party. Now, quickly explaining what needs and interests are. Needs is what you essentially need to continue with the engagement or to ensure that your business continues. Interest is where you would want where you would want your business to be in the future, but that is also something which you desire to have. So from a supplier's perspective, what would be the need? One, make sure I get my payment, because my buyer has told me that he will not pay me because there has been delays. But if I don't get a payment, I will not be able to manufacture batteries. That will lead to more delays. So essentially, as a supplier, I need to make sure I get my payment. That is very essential, hence the need. Second, the delays that have been caused in the supply chain, we need to show to the buyer that it is out of our control. It happened due to force majeure events, like could be supply chain disruptions, pandemic, epidemic, various reasons. But you have to explain it to the buyer, that is the counterparty, and show them that, hey, this was something which was out of our control and we could not control it. Please accept it. Because if they don't accept it, that is where the whole friction is coming about. Delay happened, so they will not pay you. So the origin point seems to be like the supply chain delays. So ensure that your counterparty again recognizes that. Again, this is a need, because if this is not recognized, you cannot get payment. If you cannot get payment, you cannot continue with your business. So this is absolutely essential for your business. Hence, it's called the need. Interests, pretty straightforward. I as a supplier, I'm interested to make sure that my industry reputation is restored, and I would want to secure some sort of a long-term partnership with my counterparty, because if I don't do that, it will affect me, just not in the immediate run, but in the long run. So that's why it's an interest. It is important to me, but it's not extremely important to me in the immediate run. I would want to secure it, but in the near future. Hence, it's called an interest. So here you identify your own needs and interests. This is the second limb. Third limb is what are the possible, again, needs and interests of the other party. It's pretty straightforward. The supplier said that that they faced certain financial setbacks. So because there was delays in delivery and the quality of the batteries was not met. So the buyer wants to be paid some sort of money for this damage. Because if they're not paid for that respective damage, they will not be able to continue with their business because for them, the deliveries are delayed. So they don't have vehicles to sell with batteries in it. So they literally cannot continue with their business. So that's why it's a need. Then next is pricing. As a buyer who wants to buy batteries and put it in their vehicle, I want to make sure that the pricing is consistent. If the pricing is not consistent, it will affect my customers because if the price increases, I have to increase the price of my vehicles, and that will affect my customers, and my customers may not buy vehicles from me. So that also has a big impact on me in the immediate run. So that's why I need to make sure that as a buyer, the pricing is fixed. Again, a need of the buyer. That's the counterparty here. Then are given to us in a timely manner, because if they're not, there's delays in delivery. If there's delays in delivery, then we get financial setback. So this is interlinked. So it's a need from the counterparty's perspective. Interests, very similar to the supplier, maintain reputation, obtain reputation or rather recognition in the industry that, hey, our cars are reliable, our batteries are reliable, are here being again the buyer perspective. It's an interest, it's important, but not immediately. In the long run, that is something which the counterparty would want. So that's how you identify needs and interests, pretty straightforward. And this is the third limb which you write in a negotiation plan. Fourth limb is you identify the obstacles and how you overcome them. Here, obstacles would be essentially the blockers or rather the friction points that the counterparty is creating for us. We are the supplier. We are saying there is delay, but the buyer is saying it's okay. There was a delay. It's okay, but I will still not pay you because, you know, there was delays that was caused to them and that affected their business. So that is essentially a blocker because they are not accepting our explanation on why the delay happened. Essentially, the buyer has become blind to it, and we need to show them that, hey, please understand it was beyond our control. Same thing for pricing. They're not understanding why the pricing has gone up. We are saying that it's due to rise in material costs, that is raw material costs, but they're not accepting that explanation. So that also becomes a blocker, the disagreement on the fact as to why the pricing has increased. And then third thing, the buyer wants to go to a competitor. That's a huge impact on us. So that's an obstacle because if that happens, we lose our business. So these are three obstacles. Means is how do you essentially overcome these problems, these obstacles? Very straightforward here as well, because if you want to show that the delay was caused due to global supply chain disruptions, you give them data. That data can be independent export reports, government trade data, whatever it may be, that is possible within your mediation problem. So again, very case specific, but this is just an example here. Then regarding rising costs, you can come up with an arrangement with the buyer saying that we will share the costs. We take 60%, 40% you share. So somewhat of an arrangement to make sure that the costs are equally handled or more or less equally handled so that we're able to continue. And then regarding switching to a competitor, you have to show them why you're better than your competitor. So here you can tell maybe that you can give faster deliveries. You can make sure that the manufacturing of batteries that we do for you can be prioritized. So essentially, we need to show them why they should continue their business with us. And that why is essentially answered by the how, the practical steps that you will take to make sure that they continue with us. They again being the buyer here. So this is the fourth limb. You identify your obstacles, that is the obstacles you are facing. These obstacles are created by the counterparty. And the means are something which you are offering from your side to the buyer, that is the counterparty, to, resolve the dispute essentially. Basically, these are possible solutions. Then Bhatna and Vatna, I think they were pretty well discussed in the previous session. Same thing here, you just have to write it down. If the negotiation fails, what's the best scenario for you, or the worst scenario for you? As a supplier, my best case scenario would be, sure, today I lose a customer, but that's not the only customer. I have other customers as well, that is other manufacturers who want to buy my battery. So even if this negotiation fails and I lose this specific buyer, it's okay. Everything will be fine. But again, this is based on an ideal best case scenario. Then what would the worst case scenario here would look like? That's my main big customer. I derive a lot of revenue from that customer and the contract is terminated. If it is terminated, my business gets impacted. Why? Financial losses. There can be legal disputes where the buyer can initiate a lawsuit against me and say that, hey, there was delays, there were defects in the battery that caused a lot of car issues that led to recall of the vehicles, that led to customers filing a lot of warranty claims, and then obviously the buyer facing reputational damage. So this is not the best position to be in, it's the worst position to be in. So practically, what happens if you face a worst case scenario if the negotiation fails? So this is the, again, sixth limb. So these are pretty straightforward things. I'll quickly summarize it again. First, you divide the roles between client and counsel. Then second, you identify your needs and interests. Third, you identify the needs and interests of the other party, that is the counterparty here. That would be the responding party, if you're the requesting party. And fourth, you identify what are the obstacles being created by the counterparty and what are the possible solutions you can give to make sure that you overcome these obstacles. Fifth, Bhatna. Sixth, Vatna. Very straightforward. And this here, you make it very specific to you, that if it fails, what's the best case scenario for you, worst case scenario for you, for your business. Very straightforward. This is the negotiation plan for requesting parties, and same thing for responding party. Same format you have to follow, is just that you have to flip it. Delays happen, affected our business. So you have to explain the same thing there for the responding party as well. I'll quickly go through mediation plan and then we'll be done. I'll just take a few more minutes of your time. Mediation here, the mediation plan will be made by the mediators. It is also very straightforward. First, you explain what the mediation aims to achieve. Here it would be, we want to resolve the dispute between so-and-so parties through open dialogue and mutual understanding. And then what you as a mediator can possibly contribute to the session. So it's a general summary that you have to give here in the mediation strategy, the first part here. And then also give a very, very brief summary on how will you start with the session and what can you do to make sure that the session goes properly. A very brief summary, like an introduction of sorts. Then you go into the specifics approach. You have to explain that you as a mediator, how can you as a mediator, make sure that the session goes well. The how, so here you would be conducting private sessions. Then you will help in reframing and clarifying, like how we discussed in the previous session. I think that was also very well discussed, very well explained, where if there's an aggressive tone going on, you reframe the question and then, you just help the parties throw spotlight on that and just help them understand where they are coming from, and then trying to reduce the tension to the best of your abilities. It can get pretty heated. So again, as a mediator, it's on you to show that, how you can reduce the tensions, and obviously how you can help the parties explore options. So basically, what are the tangible steps you will be taking as a mediator to make sure that the session goes properly? That's the approach. Resolution process. So now this is what happens towards the end of a mediation session. If an agreement is reached, what will you do? You can summarize the discussion. Then you can help with the written negotiated settlement agreement, where you can write it down, the specific terms and conditions agreed between the parties. This is if a resolution is reached. So what happens then? if a resolution is not reached, what can you as the mediator do? You can essentially tell the parties that we can try different steps. That's, maybe revisit this or maybe go for the next steps. After mediation, it can possibly be arbitration. So it really depends on the contract also, what the dispute resolution mechanism there is. But as a mediator, what are the next steps that you can possibly suggest to your the parties? So yeah, this is the first part, very straightforward. Second part is the goal. That's what do you want to achieve as a mediator out of the mediation? I, as a mediator, would want to make sure that my parties are properly heard, and the issues are acknowledged, but the focus is shifted from discussing the issues to actually trying to discuss solutions per issue wise, so that we make sure we do not stagnate, because the point of mediation is, again, facilitative therapeutic discussion. So we acknowledge the issues, we move forward. So that's what my goal of the mediation would be as a mediator. So that's what you would also have to explain here. What can you as a mediator possibly offer here? Then third limb of the, again, mediation plan would be, what are the alternative means that you can possibly use to achieve the goal that you have set for yourself? So for example, if your session becomes stagnated, you can possibly try to, again, reframe and be like, this is what the issue that is we are facing here right now. We can either go into a private caucus or discuss it in next session. You have various options available to you. So you explain that here, that what can you do? Then also, if it gets very complex and technical, like a lot of numbers are flying around or a lot of data is flying around, you can possibly suggest that, hey, maybe the use of a technical expert might be helpful here, like maybe a financial person or anybody similar to that. So again, depends on the context, but in a generic way, you as a mediator, what are the alternative steps that you can possibly adopt to make sure that you come a little closer to the goal that you want to achieve? So yeah, these are the three limbs. And then the fourth limb, this is also pretty straightforward. You as a mediator would have to identify the needs and interests of both parties in your head. What do both the parties need, absolutely need to continue with the mediation and with the business? And also what the both parties want to probably look forward to in the future. The idea here is that you as a mediator should be aware of what the possible needs and interests of the parties are. So that when you have identified them in advance, you can go into the session a little bit more prepared and then align accordingly. And because the parties might have different needs and interests in the actual session, but here the idea is to make sure that it is as close as possible to the actual needs and interests of the parties that will be spoken about in the session. So you have to do this from both the parties' perspective. Yeah, this was the fourth limb. So needs and interests, we had already discussed that in the negotiation plan. That was for client and counsel. For mediators, you have to identify the very similar things here as well, but from both the parties' perspective. Then fifth one, now mediators also have to give a batna and whatna. So if the mediation fails, then what's the best case scenario for a mediator? Then here what you could do is that an ideal outcome, best outcome would be the delivery timelines are adjusted because there was a delay, there was no termination that happened, but you helped in adjusting the delivery timelines. So that's what you did as a mediator. You ensured to a certain extent that the contract is not terminated, the relationship is not terminated, the relationship still continues with certain compromises. And that is something which you have played a role in. And that is something which you should be able to foresee, that specific to your problem, how can you as a mediator help achieve the best outcome possible? Same thing, another example. So instead of there being a very high price increase or being some sort of price sharing arrangement, you helped the parties achieve that there's a little bit of price increase with a cap. So again, this is something which you're helping the parties achieve. But at the end of the day, the actual decision to implement these solutions is of the parties, but you're guiding them that, hey, this is what buyer is saying regarding price. This is what the supplier is saying regarding the price. We see that there is a little bit of friction here. What can we do to best achieve, a common ground between us? So that's how essentially you're facilitating the best commercial solutions possible if the mediation is unsuccessful. And If it fails, well, first thing would be a termination of a contract, because here the supplier wants to terminate. So as a mediator, what would happen if you're not able to assist very good in a session? What would happen is the parties might want to terminate the contract. So that's one issue. Or second issue is that the buyer wants to release, again, only a little bit of the payment and not completely. But in exchange, the buyer says that I want the delivery immediately with all the improvements. So here, if you notice, in the BATNA for the mediator, the BATNA is balanced to an extent, but the WATNA is not really balanced. It seems to be lopsided, favor in one party, not in favor of the other party. So that's what would happen if you as a mediator are not able to properly facilitate a session. What's the worst case that you can achieve for the parties? So this was pretty straightforward. This is done. I'm done with the mediation plan as well. I'll reiterate. Starting mediation strategy, give a summary, give the approach you will be adopting in the mediation session. What is the practical process you will adopt once the mediation process is over? Then second limb is, what do you want out of the mediation session, the goal? Third, if you're not able to use this approach to achieve your goals, what is the alternative steps you as a mediator can take to achieve the goal of the mediation? This is the third limb. Fourth limb, as a mediator, identify the needs and interests of both parties so that you're prepared on what the parties might want to talk about. But the idea here is to reflect it as closely as possible and as accurately as possible to the actual needs and interests of both parties that they would be coming and talking about in the session. Fifth is, and sixth is your mediators, BATNA and WATNA. So yeah, that's about it. I am done with explaining how the negotiation plan and mediation plan drafting would work. I'm happy to take any questions if there are any. Oh, okay. I see one question in the chat box. It says, when we are drafting the needs and interests of the parties, are we talking about our needs and interests that we expect from the other party due to an issue, or any needs or interests a party has in the problem? So ideally, needs and interests would be the needs and interests that a party has in the problem. So I would say that the supplier's need is to make sure that the contract continues. Mediator, identify that. Buyer's need is that subcontract should not continue because there is quality issues, delivery issues, there's a lot of issues there. So I don't want to continue with the specific supplier. So I want to terminate. Mediators identify that and put it in. So you're essentially identifying the needs and interests of a party that they have in the problem.
Hi, I have a question.
Yeah.
So with respect to this year's preliminary round problems, the second round's problem is pretty much a continuation of the first rounds, right?
Okay.
They've introduced new situations, new issues, but essentially it is building up on the first round problem.
Okay.
So when we prepare the mediation or the negotiation plan, there will be places where I feel like the position and interests of both parties would overlap for these two different rounds, right? So do you think that is just given and there's nothing we can do about it, or do you think we should try best to make it as distinct as possible?
Okay, so just a disclaimer, I have not read the prelim 1 and 2 problem for this year. So I will not be able to guide you on whether whether the repetition is valid or not. And second, even if I was the drafter, I don't think I can answer that question because the drafter, I'm not allowed to answer that question. But from a general perspective, there's a reason why the prelim round 1 and 2 problems can be different, even though there is some sort of an overlap. So I would suggest you from a very generic perspective, try to keep it problem specific. Even if there seems to be an overlap, just make sure that you're within the boundaries of the problem that exists for your specific round. Again, this is just my perspective, so just take it with a grain of salt here.
All right, thank you.
Great. I don't think there are any more questions, but yeah, I wish everyone here all the very best. Thank you so much.
Thank you for that highly informative session, sir. Drafting is truly the backbone of an effective mediation. Now, before moving to the next slot and session, the organizing committee of the competition will be telling further timeline of the competition and certain rules. Over to Preeti.
Thank you, Simran. I hope my PPT is visible to all of you. I'll be giving some general instruction and the further timeline of the competition. This is the 7th edition of S.K. Misra Memorial International Mediation and Negotiation Competition. We have these number of rounds in our competition. We have 2 preliminary rounds, that is preliminary 1, preliminary 2. Then we have octa-final round, then we have quarter-final round, and then semi, and then final rounds. In this edition, we have total of 80 teams. Those 80 teams would be divided into 2 groups, Group A and Group B, consisting of 40 teams. Group A would be competing against those 40 teams only, and Group B would be competing against those 40 teams in that particular group. There is preliminary round 1 and then preliminary round 2 of both the groups and different time slots, which would be shown in the further PPT as an event itinerary. Then after that, after the preliminary rounds, from Group A, we will select 16 negotiating pairs and 16 mediators. And from Group B, 16 negotiating pairs and 16 mediators who will qualify for the octa-final rounds. From there to quarter-final rounds, they would go to 8 negotiating pairs and mediators. In semi-final rounds, we'll be having 4 negotiating pairs and mediators. And in final rounds, 2 negotiating pair and 2 mediators. This is the timeline and that event itinerary of the 3-day competition. First day, 13th March, would be preliminary rounds, preliminary round 1 and 2. There are 4 slots according to the groups, and these are the timelines. Second day would be 14th March. There would be having octa-final rounds and quarter-final rounds. Octa-final rounds is from 11 to 12:30 and quarter-final from 3 to 4:30. Then on third day, that is 15th March 2026, that is the final day, we'll be having semi-final round, final round, and the valedictory ceremony from 5 p.m. onwards. This is the basic timeline of the event. Today is 27th of February. Today we had the workshop, and also we'll be releasing the subsidiary rules. 28th of February, we'll be releasing the clarification, the questions which you have put up on the mediation problem. 4th of March is the last date of submission of mediation plan. This year, we'll be sending you the mail where you will be having the drive link of a folder where you need to upload your plans before the last date of submission, that is 4th of March 2026. Then on 10th of March, we'll be releasing the team matches where you'll get to know that from which side you will be preparing, a requesting side or responding side, for both prelim 1 and prelim 2. Then on 7th March, we'll be having a dry run session where we tell the people how the whole competition worked technically, and we'll have a mock dry run with you on this date. This would be scheduled in the evening. Then 3rd March, we have the competition, preliminary rounds, 4th March, octa and quarter-final rounds, and 15th March is semi-final rounds and the valedictory ceremony. The other problems related to the other rounds and advanced round would be released on octa-final and quarter-final round. Problem would be released after 12th of March. And these problems would be released on the SK Misra official website. Semi-final and final rounds problem would be released on 14th March. You do not need to make any plans for further advanced round. Plans are only for preliminary rounds. Some basic general instructions. Mediators are allowed to share their screen and client counsel can join from one screen. Also, all the score sheet related to the competition would be shared after 2 weeks of the completion of the competition. Then relating to this, the mediators need to join 15 minutes prior, as there are 2 mediators from different universities and college of different team codes. So they'll be given 15 minutes time and they'll be assigned a breakout room where you can have the discussion related to how they want to begin with the mediation session and how they want to take the whole mediation session together. So this will be their time for discussion. Confidential information release would happen of preliminary rounds 1 day prior to the rounds, and it would be made through WhatsApp group. So WhatsApp group would be made prior to these releases. So if you're not added to that, please contact the OC and get yourself added to that group. Preliminary round 2 confis would be released just after the completion of round 1. Then when you will be submitting the mediation plan, you need to follow some guidelines. First of all, the document should be named as follows: team code MP for mediation plan, pre-1 or pre-2, whichever mediation plan it is. You need to make 2 mediation plans, one for preliminary round 1 problem and second for preliminary round 2 problem. Same for negotiation plan. These are for client and counsel. The document should be named as team code NP for negotiation plan, requesting or responding party, pre-1 or pre-2. And 4 negotiation plans you have to make. For prelim 1 and 2, requesting and responding party. For prelim 2, requesting and responding party. These are the award categories which you will receive, and here is the specification of who will receive these awards. The best negotiating team, runner-up mediators, and other categories would be there, and client and counsel or mediators would be sharing that award. Any questions if you have, you can put it in the chat box, or you can raise your hand. Otherwise, we'll start with the mock mediation. Yes.
All right. So you've given a date for the release of team matches, right? Does that have any kind of interest for the mediator? Would the co-mediators information be shared?
No, information will not be shared. We are giving you 15 minutes time prior to the rounds for the discussion with the mediators.
All right. And during this 15, yeah.
Yeah. So if the rounds are for 9 o'clock, you need to join 15 minutes prior. If you need time for discussion with the mediators, you'll be given a separate breakout room and a 15 minutes time. There you can have full discussion about how you want to go through the mediation session.
And in the separate breakout room, would the judges be present, or would it just be the mediators?
No, judges would be joining at 9 p.m.
All right.
All the mediators need to join 15 minutes prior, that is 8:45 and respective round timing. So 8:45 to 9 p.m. you'll be getting your personal time and no judges would be involved. You can have your discussion.
All right. And is it allowed for us to contact the co-mediator in the sense that during the session, if we want to have a discussion with them, maybe with respect to setting agendas, can we?
That is done in the open session. Like when you want to set agendas, that is the only discussion which you do prior, that who will be doing what. If one is beginning with the opening statement, then one would be the person setting up the agenda. And this is how you divide the role. And if you need to have more discussion, chat box would be available. So you can have a discussion via chat.
All right. So in the chat box, we will be able to text or
privately to the mediators too.
All right. Thank you.
Yes. Any more questions?
What's about the confidentiality of the participants? Can we say our actual names in the whole process?
See, we want you to use your team codes whenever you are addressing yourself to a judge or other team member. And related to the names, use the problem names which is given rather than your original name.
Okay, as a mediator, what name I can submit?
As a mediator, you don't need to put any name. If you want, you can put your real name. That is not an issue.
Okay, fine.
There are some questions in the chat box. Yes, we'll share you the presentation of Kathleen ma'am. She has shared us the Canva link. We'll share it on the group. Also relating to all the releases of the problem, the mediation problem of all the rounds would be released through the website of 𝐒𝐔𝐁𝐄 Misra Memorial International Mediation Competition. Prelim 1 and Prelim 2 rounds mediation problems have already been released on the websites. So you have to check the website and the WhatsApp group for proper communication. Any more question from anyone? I hope if you have any more questions, we'll be assigning you POCs by today or tomorrow. So you can contact with your personal grievances there. I guess, okay, there is one more question.
Yes, I was wondering whether the CIs will also be shared via the website.
No, the CIs would be shared through WhatsApp group, only to the
Okay,
client and counsel of that concerned CI.
okay.
Yes.
And one more thing, will there be an event where the parties, the participants can communicate with each other or like discuss or kind of like get to know each other or something like
You're
that?
saying some networking event. We have not planned as such, but we can have a discussion with the authorities. If the time permits, we can have a networking session of all the competition or of all the participants.
All right, okay, thank you.
Okay. Simran, please take over the thing and allow the mock mediation team to begin with the session.
Thank you, Ms. Preet, for the discussion and clearing all the doubts of the participants. We now move towards one of the most engaging and insightful segment of today's workshop, the mock mediation. This session has been specially curated by Lloyd Institute of Mediation and Arbitration, that is LIMA, to give all the participants a practical demonstration of how mediation unfolds in real time, from opening statements to caucus, negotiation strategies, and finally resolution building. The mock session will be comprising of two mediators, Ruhani and Ankita, and negotiating pairs, first Anjali and Amrita, second Ria and Selja. Without any further delay, I invite the team from Lima to begin the mock mediation session. Thank you and over to you.
I request everyone to please wait for 2 minutes. The mediator is joining in a minute.
Meanwhile, Preet, the query which was raised with regard to the networking session, what we can do is that in the valedictory ceremony, we'll keep 5 to 10 minutes post announcement of awards for the meet and greet session. All the teams who wishes to have a interaction with the other team members, we can go ahead with that.
Okay, Dee will arrange for a networking session for all the participants.
Yes, thank you.
I request the team, if you all are ready, please start the session. We are keeping the timekeeping we are doing. We'll update you the time in the chat box. You have 60 minutes for the session, including the 15 minutes caucus. So whenever you take for the caucus, please inform us which party is taking the caucus. The other party would be sent to the breakout room.
We'll start the session.
Yes. So we'll be starting the session by the countdown of 1, 2, 3, and go. Good afternoon, everyone. I hope that everybody is in a good health and doing well. My name is Ruhani, and I have my friend Ankita. We'll be mediating today's session. Thank you for choosing us as your mediators. Parties, at the very beginning, I should really take up a pose and appreciate you for taking out your time and committing to this session. Your determination shows that how willing you are to reach amicable solutions. For the sake of clarity, to know that who is who, we will have a quick session of self-introduction. That would simply include your name, your strength to this session, and also additional question to the client is that whether they do have the requisite authority to settle out this dispute.
Yes, we have.
I echo the same from the responding side.
Yes, I do have the authority to settle this dispute.
Can parties confirm that have they ever been to the mediation session before?
Yes. Yes, we have.
Since everybody has a little clarity of what mediation process is about, I would quickly summarize what mediation process is in a nutshell. So mediation is a guided conversation where a private meeting has to be conducted between the parties who are in dispute with a neutral professional in a negotiated settlement. So having done with the meaning of mediation, I would now at this stage highlight the key features of mediation. So parties, I understand the issue at hand is quite very vital, to which confidentiality naturally becomes something very important. So whatever you would say within this room would be staying within this room only. Nothing would be used out of this room. So make yourself very comfortable since this entire session is confidential. However, you may find that mediators are using some of their notes, but that is for the own sake of clarity and will surely be destroyed soon after the session ends. I hope that I'm making myself clear.
Yes.
I can see the nodding heads. So also, secondly, parties, you can confirm that you have assented to the session voluntarily. Since mediation is a voluntary process, both the parties can come to the session and also they can leave the session to find a solution that they like. So lastly, we have that whatever you would say would remain non-prejudicial. And what I mean by saying is that whatever you would say will not be used either in favor or against of you in any court of law. So please make yourself comfortable in making out more information that would really help the mediators as well as the other party in knowing more of your concerns and aspects. Now, I should highlight that what is our role into this mediation session. So parties, our role to this mediation session is that we are neither the judges nor the arbitrators. We are here with the mere capacity of facilitators. However, we will be guiding you throughout the session so that there's no confusion in between, and we'll be summarizing you in between. Also, since we have never met before this session, we mediators do not have any vested interest into the dispute. We will ensure that we here stay to the session with neutrality. Also, we would ensure a fair and independent session should initiate, where we do not want either party to win or other party to lose. All we want is that you formulate such a solution that addresses both of your concerns as well as your interest. So am I making myself clear, or is there any doubt to that? We are open to that.
No, we are clear about it.
Since there is no doubt, I would now pass on the floor to my co-mediator to elaborate the rest of the process.
Thank you, Ruhani, for walking us through the basics. I'll now take over a bit to explain how to go about today's session. All right, parties, the session will run for 40 minutes. After this pick and choose, each party will take the floor and share their side of the story and what made using mediations today. We, as a mediator, after hearing a story, will set the agendas or main issues, which will act as a roadmap for our session. Agendas are simply the issues and interests that both parties want to address during the session. It will help us make sure nothing gets mixed. And of course, at any point, if the parties feel anything they would like to add, removed, or modified from the agenda, please feel free to let us know. Again, we want this session to work for you, not the other way around. Once the agendas are set, we'll move into a joint discussion. This is where we explore our agendas together, ask clarifying questions, and address the underlying interest of both the parties. The idea is to find solutions that work for both the parties, rather than just trying to win or lose. But sometimes the conversation may still slow down, or there might be things to keep in private. In that case, we as a mediator will talk to you separately and have a short session, private or caucus. During caucus, we as a mediator will talk to you separately and listen to your concern. and anything you share there will be strictly confidential unless you give us your explicit permission to share with the other parties. Then we'll move into the closing statement. And even though mediation is an informal process, I think a few ground rules will help us ensure a smooth session. So the session will run for 40 minutes. Set aside 10 minutes for private caucus. Please let one person speak at a time. Use collaborative and respectful language throughout. Remember, this is a safe space to talk openly and honestly. So before we begin, parties, am I making myself clear?
Yes.
Does any of the parties have any question or anything they would like to ask? Please feel free.
No, we don't have.
Great. With that, we'll start with the opening statement. May I invite the requesting party to take the floor and share your side of the story?
Greetings, everyone, and thank you, Ankita and Ruhani, for explaining the process of mediation so well. And thanks to Rohit and Anjali for accepting my invite and coming to this process. I am Shruti, and before I begin, there is one thing that I want to be clear. Today, I'm not standing here as a businesswoman. I'm standing here as a daughter and as a sister. For others, this place might be just a homestay, might be just Sharma's Bhavan in beautiful city Mussoorie. But for me, it is where Papa taught us responsibilities, where Mama showed us what warmth truly feels like, and where I and Rohit, we grew up together. We built memories that shaped us who we are today. And I completely understand what that Papa wants peace after years of hard working. And he deserves that. And I truly understand Rohit's concerns as well that he has his own family, he has responsibilities, and cannot come back and run BNB together. And I'm not asking that. But for me, selling this entire property is like closing a chapter without even trying to rewrite it. Because we are not talking about a piece of land. What we are talking is selling a place which holds generations of love, efforts, and identity. So, all I want to say is can't we just pause and ask if there is any middle path, or if I can take the whole responsibility, or if we can protect Papa's retirement and family's legacy together? Trust me, I'm not here to oppose anyone. I'm here because I don't want this decision to divide us. This place is very important for me. It holds my childhood memories and it is our identity. But before we protect this in future, I want our relationship to be protected. And I'm not here to rush to an ending. I'm here just to find a solution so that we can move forward.
Thank you, Shelza, for letting me over. Greetings, everyone. I am glad we have this chance to sit together and discuss how this process. This dispute is not simply about selling the property, it is about preserving the family legacy. Sharma Bhavan is located in Mussoorie is more than B&B. It represents year of hard work, shared sacrifices, and the memories the family shared during that time. For Shruti, it is not just a business, it is home, identity, and heritage. We fully respect its concerns about the financial securities and the practicality. What I believe, selling BB is not only the sole option. My client stands not in opposition but in preservation. She is willing to assume operational responsibilities for the financial arrangements for the Mr. Sharma arrangements after retirements, financial fairness for Rohit, and continuance of the Sharma Bhavan legacy. During this session, I would like to discuss upon first and foremost is financial security, second ownership, clarity, third family relations. We are here in the good faith, seeking balance, not victory, with the cooperations and understanding. We believe a solution can be reached which will be beneficial for both the parties. Thank you. Now the floor is yours.
So just before the responding party initiate, I would quickly summarize what are the interests of the requesting party for everybody's clarity. So we understand that how requesting party is emotionally connected to Sharma's Bhavan and do respect the retirement decision of their parents. However, selling of the property is not mutually accepted. The management responsibility should be renegotiated. However, they are willing to reach out the amicable solutions. Now, I would request the responding party to initiate with their opening statements.
Good evening, good morning, everyone. I am Rohit, younger child of Mr. and Mrs. Sharma. I would like to thank the mediators for facilitating this session and providing us the platform to discuss the matter. I acknowledge their guidance and their timing. I agree whatever Shruti has provided. Of course, Sharma House has been a legal heritage for our family, of our cherished memories and the importance that it holds in our lives. Though for the years we have maintained the reputation of BNB, but now the circumstances have changed. As I am living in another city, it has become difficult for me to be involved in the daily affairs of the BNB. Taking my perspective in consideration, I believe selling the property would offer financial security to both of us. Currently, my personal and professional responsibility requires me to focus on my current situation and my family's future. It would be a feasible option which will also help our parents to enjoy a comfortable retirement. I do not disregard the fact that the property holds our childhood memories, but for a secure future for all of us, I will put more emphasis on the selling of the property. Now, I would like to hand over this to my counsel for further submissions.
Good morning to everyone present here. Uh, Firstly, I would like to thank the mediators for explaining the process so effortlessly. At the very outset, I would like to make it clear that Rohit is not here to oppose his family or nor to disregard the emotions attached to Sharma's Bhavan. The BNB has been a cherished part of the Sharma's family for generations, and that it holds a special place in their memories in Missouri. Rohit himself grew up here, helped in the business, and shares the same emotional history attached to the property. However, the reality is very different from the past. Rohit is settled in another city, has a demanding professional life, and has family responsibilities as well of his own. He is simply not in a position to return and manage BNB on a full time basis. From his perspective, continuing ownership of the property without being actively involved creates uncertainty, financial risk, and long term stress. Rohit's position is not based on disregard for family tradition, but on genuine concerns about feasibility, fairness, and long term sustainability, especially when responsibility would fall unevenly on one sibling. Therefore, he approaches mediation in good faith that respects both siblings' rights and future needs. And thus, we look forward to a meaningful session. Thank you.
Parties, I understand where you're coming from. To just quickly summarize from what you shared, it seems like Rohit really values the memories and importance of Sharma Hamun as it was a great memories of his childhood too. But at the same time, because of his career and responsibility in another city, managing the B&B feel difficult and unrealistic. So selling the property feel like a sensible, practical solution for you. And believing that selling the B&B would also provide you financial security for both of you. Does my understanding correct, parties?
Yes, yes.
Now, with that, we have the understanding of both the parties. I think I now have, after listening to both the parties, it sounds like we have some main areas we should focus on that are pretty clear. With that, I would like to move us towards the agenda of today's session. It seems like we have three main agendas in hand. And remember, these agendas as flexible parties, so feel free. The first agenda is financial security. Second, ownership. And the third, preservation of family relationship. Is both the party comfortable with the agenda?
Yes.
Ruhani, is there anything you'd like to add, please?
That is so well explained by you, Anita. However, parties, I want to reaffirm you that agendas are not a rigid concept. They are flexible and can be rearranged as per the party's priority. So please make yourself comfortable. And is there something to add on to the agenda if parties feel so?
No, it's all right.
Since everybody is comfortable, we would initiate with the agenda one, that is financial security.
Thank you so much, Ankita and Ruhani, for stating the agenda so well. As Rohit, you have mentioned in your opening statements that you are facing financial crisis, and as a sister, I feel for you. I feel bad for you, but there are few things that I want to be clear about. And can you please help me understand that how serious is your financial situation and what are you really dealing with right now, so that it will help me and you to move forward with the discussions?
Of course, Shruti. The financial situations of my family and my construction business is not been a good. So for the same, I will initiate that the property should be sold out, and it will make a better option for me.
I completely understand what you are saying, Rohit. But, and I understand that you have responsibilities and you have a career, demanding career. And I respect that. But I'm not asking you to give up your life. I'm just asking you to help me and help me to protect this place. I'm just asking you to provide your support. Selling this property feels like we are selling a part of our childhood. We both of us are truly connected with this property. And we can't just give up on it just because we are facing financial issues. I think we should go for more options rather than selling a property.
I acknowledge that you have deep emotional aspects and sentimental connection with Sharma's Bhavan. So do I have. I also have some financial obligation towards my family. Adding to this, I am living in another city. It is more than impossible for me to be involved in the daily affairs of BNB. And if I talk about the profit the property is rendering to me is almost zero. Most importantly, I need these funds for expanding my business and to preserve myself from the bankruptcy.
Adding on to my client's point, Rohit is not opposing his sister. He is only protecting his financial security and future stability, which is a legitimate and reasonable interest in this mediation, as we all know. So, and as Rohit lives in another city and is engaged in his demanding career, he does not have the time or operational experiences to run a family BNB on a daily basis. And I hope you take this point into consideration.
Yeah, I am understanding that for you, you are looking for the financial stability and the practicality as your business is not growing group. What we believe that we have not only have one option for selling out the BNB, we can go for the other options. We can go for leasing out the BNB. We can go for full ownership, or I can say sole ownership to the Suti. We can discuss it upon this if it goes well with you.
I will take this in consideration that the selling of the Sharma Bhavan will render equal profits to both of us. I agree that Shruti has deep emotional connection with that Bhavan, but that would allow both of us to move forward for a fair and better option. I may sound mean to you, Shruti, but there's no other option left to me. If you can provide me a better solution, then the floor is yours.
I understand, Rohit. And I feel
Just quickly
happy
pitch
that
in,
you are
please.
understanding my point of view as well. As I've already mentioned earlier, that this property is a part of our childhood. This property showed us how we are today, showed us how Papa worked on it. He had given his whole life to it, how Mama treated the guests. It is the reason I believe that who we are today, we are because what we learned from here. And I think that since you are facing so many issues and you are thinking about selling the property, I feel what we can do is I will take the responsibility of the whole property. I will manage everything. I will take the responsibility and you just have to support me.
I just want to clarify out what my client want to say, that if we want to propose out, if you give complete or whole sole ownership to Shruti for the BNB, and she will be responsible for all the management, for salaries, and whatever the take place in the BNB. And it will be helpful for you. You do not have to travel. It will release your financial stability, and it goes well with you. We
To
can
this
discuss
quickly
upon this.
pitch in parties, may I just quickly summarize from what I'm hearing? Shruti feels strongly that Sharma government should remain in the family as it represents your family history and inherit, and most importantly, the core foundation of both Shruti and Rohit and their family. However, Rohit feels that keeping the property may not be practical for Rohit, especially because he lives in another city and having his responsibilities on that city. At the same time, Shruti has also made a proposal to Rohit for transferring the ownership to Shruti as she is living in Missouri and can manage the BNB alone and solely. So, Rohit, would you like to add something to the proposal, or what do you think about it, please?
Okay, if I agree to the selling of the property, then I would ask Shruti that how it will help in financial security, be protected of mine, and if the BNB continues to run under control of Shruti, how she will manage it and how will be the profits will be divided.
Adding on, we fully respect Shruti's emotional attachment to the family home. However, we must draw a clear distinction between sentimental interest and legal and economic entitlement. Emotional value cannot substitute financial security. When a person has real responsibilities towards his spouse, children, and long term commitments, and apart from all this selling of the property and all, as you proposed that we can have other options as well, so my client is ready to explore the other options apart from sale, but the condition here thereby being is financial security protected in a concrete and enforceable manner.
That is just a
I'm so
minute.
sorry, Ms.
No,
Vani.
that's fine.
I just want to continue out. Like for the ownership, as Rohit asked, she will be responsible for day-to-day managements, staff supervisions and the salaries, maintenance and the repairs of the BNB, financial risk during the low sessions or whatever will be take place, legal and the comprehensive requirements. By ownership, we mean that you, Rohit, you will be free from all your duties, and Shruti will be responsible for all the duties which are going to take place during that time period. Shruti, you can continue for profits.
Yes, as my counsel have already mentioned, that I will be the one who will be managing everything. I will take the responsibilities. I will take the risk. I will be the one managing the staff, the things that will be needed to run the BNB. Everything will be managed by me. But I just want your support as a brother, that you provide me the whole ownership, and we should think about keeping this property rather than selling it. And we can, in return, to manage your financial security, in return we can provide you with a share of profits that we will get after the BNB will run properly.
So
If
just for a moment, that is, let me clarify that a proposal had been made that now Rohit is showing willingness to share or to transfer the share part of his property. However, we are much clearer on the agenda of ownership. However, for the responding party, the agenda of financial security remains the same. So, Shruti, would you please explain that how the profit has to be clarified, and also Rohit, since the financial stability was one of your major concern, would you like to share that what financial arrangement would you like to feel to share to us that will make you feel comfortable and secure?
Thank you, Ruhani. As I have said already, that I'm ready to provide Rohit with a share of profit that I will get from the BNB, and we can do that. I will provide him 40% of the profits if he is willing to give me the. Am I audible?
Yes.
So as we are willing to give Rohit 40% of
the shares
shares of the profit, and if he is willing to give me the sole ownership.
I acknowledge the fact of yours, Shruti, but as we are the co-owners of the property, so the emphasis should be placed more on 50-50% distribution to both of us. 40% of profit is different from 40% of ownership. And if the profits decline as the hospitality business in Missouri, the earnings would definitely fluctuate. Taking this in fact, I can assume this will not render the financial security, and my primary concern is financial security only. Your management effort can be compensated thoroughly, but ownership profit should remain equal. Since I own half of the property, I should receive half profit, and equal sharing would prevent future disputes and future mediation processes as well.
If Shruti wishes to continue the B&B, Rohit does not object to her passion. But if the property is to be retained by Shruti, Rohit must be compensated with a fair and market based value of his share, or a legally binding arrangement must guarantee him a stable and predictable return with a clear exit option in the future. So, my client Rohit, as placed on record that this dispute is not merely emotional in nature, it concerns the exercise of his lawful ownership rights over the Sharma's Bhavan. And as Rohit is the co-owner of the property, his ownership is equal in law and cannot be reduced to a passive or symbolic right, and merely because he does not reside in Missouri.
We understand that according practically it should be 50-50% shares between the parties, as now they will be the co-owners of the BNB. But we have decided the 40% of the shares at Shruti will be responsible for all the risk. In the 40%, just to be clear out, only profit will be shared out. Whenever the law or the season is not there, no risk, or as you have mentioned out, Rohit, in your speech, that BNB may not work due to some sessions or something, then only the profit will be shared, no risk will be shared out throughout.
And I would also like to add few things. As a sister, I just want to help you, Rohit. I'm just taking all the responsibilities. I'm just giving you the profit. The 40% of profit will be yours, and there will be no changes in that. I will be the one managing everything. I will be the one managing with the losses. You just have to give me the sole ownership.
The starting point is very simple. Rohit and Shruti are equal children of the family. Okay, so there is no prior arrangements or documents that give either sibling a superior legal beneficial right. So therefore, in law and equity, both stand on equal footing. But apart from this, anyways, I just want to know that can you clarify the timeline for providing the funds rendered from the profits?
Agreeing to the point of Anjali, I would like to know the structural compartments of that funds that will be rendered to me, and what timeline should be preferred by you guys.
I completely understand, Rohit. What are you trying to say? But I think my counsel is more good with the numbers, and she can explain you well about the structure. Over to you, Ria.
Rohit, thank you, Shruti. As Rohit, you have asked for how we will be going 40% shares, as you mentioned, whatever the profit will be there in the monthly basis, or we can go for the 6 months, as it will be between you. You both are the same, so you can go it anyway, and the shares with it will be shared 40% with you, and we will give you 40% of the profit. Not we are not able to give you immediately, but after the 2 months we will give you security, or particularly 40% of the profit every month if it goes well with you. As you know, immediately we do not have funds, and right now BB is not in a good state.
As my need of money is urgent for my future of my company and my family, so I can't agree to the proposal made by you. But and being not satisfied with some of your aspects, I request the mediators if they can provide me with a caucus session.
Yes, parties. To just quickly summarize, it seems that the financial security is important concern for both of the parties. From what we understand, Rohit mentioned that the receiving financial support is important, and as he has agreed to transfer his ownership right to Shruti, he preferred the receive money as soon as possible. And at the same time, Shruti explained how she is willing to give 40% of the profit from the BNB because but only after 2 months because the property will need renovation and preparation before it can generate the income. At this moment, it seemed difficult for Shruti to arrange the money immediately. So the responding party has requested a private caucus. Is the if the requesting party is comfortable with that, we can have a private caucus with the responding party.
Yes, we are comfortable.
Remember, parties, this is a private caucus, anything.
Mediators, maybe there is some
Yes,
confusion.
just
Yeah.
wait for a second.
Okay.
Yes, parties, I have already told you. Let me remind you again. This is a private caucus, anything. Okay. May I request the requesting party to join the breakout room?
I respect.
Parties, let me remind you again, this is a private caucus. Anything you share there is strictly confidential unless you give us your permission to share with the other parties. So feel free to talk openly and honestly and raise your concern with us. We are here for you and will guide you throughout. Please.
Thank you, mediators, for providing me this session. I respect the emotional value it holds for us, especially for Shruti in particular. I fully understand Shruti's desire to preserve and renovate the same. However, I am currently facing serious financial challenges in my construction company. I have been working towards expanding the business by establishing an internal design department, in respect of which I need instant funds. Without this immediate investment, there is a possibility of bankruptcy, as market is demanding more. So it would be helpful for maintaining the stability in my business. This expansion not only bring a valuable opportunity, but will also be helping in creation of long-term stability and growth opportunities.
And it is important to note that without timely investment, the company faces a serious risk of financial instability, which my client would face currently and in future as well. And expecting him to postpone or sacrifice this opportunity without providing him a financial secure alternative would place an unfair burden upon him. In fact, Rohit is ready and willing to actively support the renovation with the help of strong professional network of architects and construction professionals. Anytime when this urgent and legitimate financial needs are addressed in a concrete and timely manner.
I can see parties, these are the very important concern for you. You are in a business of construction and you need the money immediately. If the parties have any proposal or any other concern?
I can help.
Yes, I can help Shruti in the renovating process of the B&Bs, and if she can provide me an immediate fund for the same.
Uh, yes, parties, I think this is a great proposal. And are you feel comfortable if I share with the other parties?
Yes, of
Yes,
course.
sure.
Of course. Now I may request you to join the breakout room. We can have a private caucus with the requesting party as well.
Yes, sure. Go forward.
Please wait for 1 minute. We'll just provide you with the breakout room.
Sure.
So, parties, this is a caucus session. And let me reaffirm you that whatever you would say in this room would be saying in this room only. So, parties, this is a caucus session, and let me reaffirm you that whatever you would say in this room will not be shared to the other party until and unless you give us the explicit green light to share us to do. However, we got some information from the other side that we would like you to consider. So, from what we heard from Rohit is that they need an immediate requirement of money that is for the expansion of the construction company to establish an internal design department. But Rohit lagged behind the financial or capital shortage, and that 2-month gap is affecting their plan to execute. However, they made a proposal that since they are looking for architect, they would like to have your proposal of renovation for the same. So, parties, do you agree? And what are their concerns? We would like to consider that. Over to you, parties.
Thank you, Ruhani, for explaining it and telling us what their perspective is. As I've already said, and as both of you know, that I am facing a lack of funds right now. I need to renovate this B&B because I am truly connected to this place. This is where I have spent my whole childhood. I cannot just let this place go because it holds generations of love, efforts, and identity. This place holds our identity. For me, this place taught us who I am today. And I want a proper renovation of this place. And for that, I need funds. If I will not invest right now, we will risk losing guests and income in future. And for that, I have already saved 12 lakh rupees for the renovation purpose. And that is the only fund I have right now. If I agree to give them the immediate amount, because of renovation, because BNB is not giving me that much earnings that I provide them with the 40% profit right now. Renovation need time. It is not something which can be done in days. It takes months to be done. And I think for me, it is very difficult to provide them immediate funds.
Yeah, just I want to clarify out as Jani asked for that, are we ready for the renovations with them? We do not have any issue if they are ready to do our renovations within the 12 lakh rupees that Shruti has saved from her own savings, and we can agree for it. But as we have mentioned out, we are not able to give them money immediately. But if it goes alternately with work that we can give them 20 lakh right now, it can, and after 2 months we can continue for the profits.
So, the parties do agree that they would accept their proposal of renovation. However, they would not be able to give them or satisfy the immediate need of finance, but they would be providing 12 lakh of the rupees for renovation to the other party. Am I right to say that?
Yes.
So, would you like us to facilitate your proposal to the joint session and
Yes.
addresses your concern?
Yes, yes.
So, are you comfortable to share your confidential information with that of the other party?
Yeah,
Yes,
sure.
sure.
Sure. So we should now back to the joint session, and we'll have a other session. We will address your concerns.
Okay, mediators.
All right, parties. We had a fruitful private caucus with both the parties. From what the parties have shared, Rohit is doing a construction business and he is willing to give you renovation work if Shruti is okay with that. And Shruti, on the other hand, is willing to give rupees 12 lakh for Rohit businesses as he need the financial security as of now, and they will continue giving 40% of the profit after 2 months as they have previously stated. Are both the parties good with the proposal? Anything they would like to add and discuss, please feel free.
It's fine. It's fine, yes.
We are good with it.
We are good.
Both the parties do agree the proposal, and they agree on the fact that 12 lakh rupees would be given to Rohit, to which that would satisfy Rohit's immediate need of finances. I would like to know that our party is comfortable in going out to the next agenda, that is future responsibilities. Or is there something to add on, Ankita?
Yeah, Ruhani, okay.
Yes, I want to add something.
Yes,
If Shruti
parties
is
feel
ready to immediately invest me for the available amount of 12 lakh rupees, so I am in a verge of it that I can provide her with that renovations, and it will also that amount of 12 lakh rupees will also help me with the immediate fundings. So it is well for me.
Yeah, we are ready to give you 12 lakh rupees immediately, or I can say after the sessions, we are ready to give you. But can you clarify around how much month it will take around in the renovations so we can continue forward?
Like in normal circumstances, it will take like 2 6 months as the building is in deteriorating phase. So if we can, yes, I can assure you that 4 months will be enough for me to make it in a better state.
I think parties are ready to join hand in this session. Shruti is willing to give her 12 lakh to Rohit for renovation of their BNB, which I think is a fruitful um, uh, discussion right here. Is the parties are comfortable with both the agendas? Now we can quickly move on to the agenda 3 as we are in a time constraint here.
Yeah. Yes.
Yeah,
Yes,
sure.
parties.
We
Now
are fine
let's
with it.
just quickly move on to the preparation of future relationships, and uh, any of the parties can start.
As Rohit have already agreed with me and has showed his interest in not selling the property, and I am also very happy that we have came to such agreements. And since he have asked about the 12 lakh rupees immediately, we can provide him immediately so that he can work with his construction company. And honestly, if I want to state what I want from why I came for this mediation session is because I truly want well-being for my brother. I don't want this dispute to end our relationship, to divide us. And that is why I am here. I am looking forward to have a good relation with my brother and his family. We are siblings, we have spent the whole childhood together. Both of us have always wished good for our siblings. And that is why we are here today. I hope that Rohit also feels the same.
I acknowledge you, Shruti. I feel the same way as you are feeling right now. Our relationship as a brother and sister means a more, and more to me. This bhavan is important, property ever could be, but it is not important as much as you are for me. You are my family. You have been a great supporter for me in my bad times. Since childhood, we have shared many cherished memories. I value you not as my sister, but as someone who has always been a source of support as like my mother. I fully agree that at the end of the day, we are family, and this is what all it matters.
And moving forward, Rohit has come to this mediation not only as a co-owner of the property, but first and foremost as a son and a brother who deeply values his relationships with his family, especially with Shruti. For him, preserving the family bond is as important as resolving the financial issue. Rohit understands Shruti's emotional attachment and her desire to protect family legacy. In fact, Rohit is consciously trying to find a solution and that allows Shruti to remain connected. And today, finally, we are at a solution, I hope, if everybody agrees. And while also ensuring to seek clarity and fairness, that he does not feel that his own future and responsibilities are being sidelined. Thank you.
That is so great to see that both the parties have somewhere reached to a unanimous solution. So, since we have covered the entire agenda that we initiated in the commencement of the session, so before I conclude today's session, I would sincerely thank you, both the parties, for your grace and your commitment that you brought to this session. Mediation is rarely easy, but what made it very fine is your willingness to listen, even when it was difficult. And that is why we here stand by it. Our session was a success. However, it is important to document the resolved disagreement so that we do not have any future ambiguities. So, parties, for the first agreement, I would like to assure you that the sole ownership would be with Shruti. For the financial security, Shruti would be giving you 40% of the interest with no risk involved. However, Rohit is also be providing the architectural contract to Shruti, and that would also satisfy the immediate need of the finance to that of Rohit. Lastly, both the parties are willing to continue their relationship as a friendly note. With that, to add on, I will pass the floor to you.
Thank you, Ruhani. I just want to take a moment to appreciate both of you about the way you have shown and engaged in today's session. Today's conversation was not always easy, but you have shown great respect towards each other and moved from your concern to a practical, amicable resolution. Thank you for trusting as your mediator, and thank you for trusting the process and for being open with each other and for choosing mediation. I encourage you to carry forward and the cooperation and wish you the very best moving forward. Now, I invite the requesting party to begin with their closing statement.
Thank you, Ankita. And first of all, I would like to thanks to Rohit for understanding me and for coming to this process, and because of which we came to an end and we agreed upon so many things. There were so many problems, so many disputes between us, and we finally resolved it. And today's agreement reflects that it's not just about financial understanding, it is more of our emotional connection. And with your cooperation, Rohit, I appreciate, because of your cooperation, we have reached to the agreements. And I feel in future we will come together, work together. We will bring the BNB to a success together. And I would also like to thanks to the mediators for explaining us, for taking us through the process so well. Thank you so much.
I would like to thank both the mediators, Suhani and Ankita, for explaining out and helping us throughout the session, being with us. Thank you, Rohit and Council, for being accepting our proposals for the ownership and the Shruti main object not to sell the property, and that's we come for. And looking forward for the good relationships, what I can say between the brother and siblings more than this.
I would like to express my sincere gratitude to the mediators for guiding us through this process with patience and goodwill. And so do I feel for Shruti as well for coming to an agreement. I respect the decision to retain the property within the family. And I truly appreciate Shruti's willingness to take responsibility for managing the BNB. My intention has never been to create conflict, but to find a fair solution, to reach a balanced solution. And that respects both our family and our individual needs. Thank you, Shruti, for reaching an agreement and everyone for facilitating this session. Thank you. Thank you.
I sincerely thank you all for providing a calm, fair, and respectful forum for dialogue in this sensitive family matter. I would also like to thank Shruti and her council for their openness, cooperation, and willingness to engage constructively throughout this process. And lastly, thank you, mediators, for your guidance and efforts in helping both parties move forward a balanced and mutually respectful outcome. Thank you so much.
Thank you, team, for such a presentation. What we just witnessed was not just a dispute being discussed, but a dispute being understood. That is the essence of mediation. Today has not been about learning a procedure, it has been about understanding a philosophy. Mediation is simply not a ADR mechanism, it is a movement towards dialogue over dispute, resolution over rivalry, and collaboration over conflict. Workshops like this prepare us not only to competitions but for real world legal practice, where the true strength of a lawyer lies not just in arguing cases but in resolving the conflicts efficiently. I would now like to invite Dr. Mohammed Salim, Senior Director and Dean of Lloyd Law College, to deliver the vote of thanks.
Good afternoon, everyone. I've been part of this workshop since morning when it all started today. And I'm very excited and thrilled to see the progress of this workshop for all my participants in this competition. I'm very grateful and thankful to the speakers of today in the workshop, especially 𝐼𝐁𝐵 ma'am, who has taken us to understand the mediation process. And then I'm thankful to the presence of senior advocate and national treasure and globally known personality in our legal profession and especially in mediation and arbitration, Shriram Panchu sir. His guidance, his way of making mediation amicable and nationally and globally known was very evident from his conversation and talk today. I'm thankful to the presence of Kathleen ma'am. She has been a great source of inspiration and guidance to all of us in last many years. We have seen his presence every year and guiding the teams all across the world and judging the students community and preparing new generation of lawyers into mediation. We are thankful to the presence of Pascal Cornwallis sir for always being here. Earlier he judged the finals 2 years back and took the workshop to twice or thrice in our competition. And today also very evidently being taking things to such a quality that it has to be of national international standard. I'm thankful to one of the resource person who joined and gave a talk on the role of a specific person in the process. And I'm thankful to my team of students who have been playing the role of mediator and arbitrator in the mock session, which is just now convened in this competition. So extremely thankful to all my OC and all my volunteers or my IT team and everyone who made this day possible, along with Ms. Daisy and Ms. Preet, who have been coordinating with everyone, and Simran, who has been a constant all through this day. So thank you everyone, Abhinav, Simran, and all the team members of this 𝐒𝐔𝐁𝐄 Misra 7.0. And I hope the way you people are handling this competition, it is going to make a history and better and newer shape in this legal education and legal skill development exercise in the whole world. Thank you, everyone. Thank you for joining.
Thank you, sir, for your kind, appreciating words. With this, we officially conclude the workshop of S.K. Misra Memorial International Mediation and Negotiation Competition 7.0. On behalf of the organizing committee, I extend heartfelt gratitude to all the esteemed speakers, trainers, faculty members, and forward to your enthusiastic participation in the competition ahead. Until then, keep negotiating, keep mediating, and keep building bridges instead of walls. Thank you, everyone. Have a great and wonderful day ahead.